So good afternoon, everyone. Welcome to the Appellate Division First Department. There's a little note here that says over 6.5 hours of argument. So that's not happening. So we're just going to put that down, ignore it. So we have read your briefs. We are familiar with the record. And so therefore, I am going to request that you only request the time that you actually need to argue your respective cases. Okay? First case, People v. Leopoldo, Bellow. Six and two and six. Chris versus the City of New York is submitted. Did I get something on this case stating that there was a substitution of counsel? There was a proposed substitution of counsel, and the respondent was requesting the adjournment of the oral argument? So I had denied the application for the adjournment of re-argument, and so therefore, since I denied it, we're going to have this submitted. Thank you. Phillip Matter, Phillip S. Submitted. 132nd Street versus Stewart. Five and two and five. UMI Holding versus Hillman. Six and two and six. Ferraro versus New York City Department of Education is submitted. People versus Delano Johns is submitted. 1035 3rd Avenue versus Pure Green, New York City. Five and two and four. Campbell versus New York City Department of Education.
Good afternoon, Your Honor. William Yamasroken for the appellant, 6 and 2.
Five and two and five. Silverstein versus Telestock. There is no respondent. 4 minutes. Kavorka versus Applied Projects. Where are you? Oh, okay. Right, there's a voice over there. 4 and two and four. People versus Edward Greenman is submitted. Yanes versus the City of New York. Eight and two and nine. Chen versus New York City, New York Hospital Medical. Five and two and five. People versus Stephen or Stefan Robinson.
Appellant requests 6 and 1 in rebuttal, Your Honor.
5, 1 and 5. Booth versus Otis Elevator.
Appellant requests 6 and 2, Your Honor. Respondent requests 5.
6, 2 and 5. James AG versus Leasing Expenses Company. 5-1, 5-1, and 6. Mullins versus Center Line is submitted. Dumfay Pharmaceutical versus Lubris submitted. First case for argument is People v. Leopoldo Bellow. The clock started running already. Oh.
May it please the court. Good afternoon, your honors. Michael McGregor from Debevoise and Plimpton, pro bono counsel with the Office of the Appellate Defender on behalf of Mr. Leopoldo Bellow. I would like to start with point 2 in our papers. The trial court's failure to charge the jury to not draw any unfavorable inference regarding Mr. Bellow's silence at trial requires reversal. It is undisputed that defense counsel requested the instruction.
Counsel?
Yes.
Did the trial court inform the jury during voir dire that the failure of the defendant to testify, that they were not to draw any unfavorable inferences from the defendant's failure to testify?
Yes, he did inform them during voir.
And did the court also instruct the jury before opening statements, give the jury the same charge before opening statement?
Yes, that is accurate. I have 2 points in response to that. CPL section 300.10 subsection 1 dictates that this charge is to be delivered at the close of summations. Additionally, 5 days passed when the jury had received the preliminary instructions, and this case was sent to deliberations.
Counsel, why wouldn't this be harmless error, assuming it was an error to not give it during summation based on the overwhelming evidence in this case against the defendant?
The Court of Appeals has made clear that this is not subject to harmless error analysis, and that was the People v. Britt decision. So that's the Court of Appeals has made clear that is the law here.
What about the fact that the court gave the jury a written charge, and in that written charge, it stated that they were to draw no unfavorable inferences against the defendant for his failure to testify?
There was no written charge actually submitted to the jury. The defense withheld consent to the trial court submission of written instructions to the jury. That's at the transcript at page 53. So there was the issue here is that there was no written charge submitted to the jury. The court actually had prepared the written charge. It looks like when he presumably read the written charge, intended to deliver the written charge, intended to deliver the adverse inference, reading off of this written charge to the jury, but then failed to actually give the written charge in his final charge to the jury. And if I may just go back to your point about the preliminary instruction, the issue is that there was 5 days between when this case was given to the preliminary instructions and when it was sent to deliberations. And so in those 5 days, it was interrupted by a weekend. The jury heard a plethora of evidence and argument, and we just cannot take the chance that the jury may or may not have remembered such an important instruction.
Counsel, was this objection adequately preserved in the record?
Yes, I think
How was it adequately preserved?
I think it's important to look at the context here. The court here actually invited the counsel to object to the charge that was given. So, to the charge. So he said at the end of charge, he said, "Are there any objections?" He said, "Are there any objections to the charge?" And then the defendant said, "If I missed it, I apologize. I didn't hear the defendant not testify." So when you look at the specific instance, he's inviting them to give an objection, and she gave an objection. "I didn't hear the defendant not testify." And if you go even further and look at his response, it was in there. It was clear that he understood the nature of the objection.
Didn't she ultimately, because if she had persisted in the objection, wouldn't the judge then have just checked and given the charge if it wasn't given? If she had been more clear that she actually was making an objection to the lack of the charge.
There is no more magic formulation that defense counsel must adopt in making an objection. The only requirement is that counsel apprised the court of the nature of an objection. And it's clear that here she apprised the court of the nature of an objection.
But isn't the point of the objection so the judge can then have a chance to cure it if the judge agrees? And if it's not clear that an objection is being made, then the judge never gets that opportunity?
He was given an opportunity here to cure the objection. Here, he said it was in there. He understood what the objection was. He understood there was she was objecting to the fact that there was an omission in the actual, an omission in the jury charge. The fact that he said it was in there, he understood the fact that she was questioning the sufficiency of the charge, and he was saying that it was in there. That was his opportunity to actually go and say, this is my opportunity to correct the charge. The fact that he did not do that is on the judge. It's not on the defense counsel to prove up the fact that the judge made an error. It's not on the defense counsel to establish that the judge made a failure to give the charge that was requested.
So counsel, again, given the overwhelming amount of evidence, including the surveillance video tape, why would there not be a harmless error analysis properly?
Because the Court of Appeals has made clear that this is not subject to harmless error analysis.
And now, in the Brick case, the charge had not been given at all. The jury had not been told anything about the presumption of innocence or no negative inferences given to a defendant who does not testify. Was that correct? Was that not? Is it not correct that in the Brick case that had not been given? I think in the preliminary instruction, something like that.
Again, the statute requires, and this is the statute that was being interpreted in the Britt case, the statute is to be given at summation.
But my point was, aren't the facts here different than those in Brick?
The facts are different than those at Britt, but the fact that still remains that there is no question that the jury did not receive a charge of fundamental importance before deliberations, and the fact it still remains that, can I finish my point?
Yeah, please.
The fact still remains that the final instructions are the ones that are at the forefront of the jury's minds when they go into deliberations. And the fact still remains that what we fear the most is when juries go into deliberations, they are questioning, why didn't Mr. Bellow, when they do not hear this instruction, they are questioning, why didn't Mr. Bellow testify at trial? And that goes to something that is the presumption of innocence, and that goes to the burden of proof. And that is something that the Britt court does talk about. And that is the concern here.
Thank you.
May it please the court, Alice Wiseman on behalf of the people.
So, counsel, in response to my question, I thought that there was some distinction to be made between Brick and the facts in this particular case.
Judge, I should say, and I cannot cite these cases to you, there are appellate division cases which have found that in terms of the Britt issue, that delivering the charge in the preliminary instructions is not a substitute for the mandate that the Court of Appeals established in Britt. To be sure, the Britt court does say that it does not say that there are no circumstances in which this could be harmless error. And if there are any circumstances in which it could be harmless error, that would be this case.
But did they go into a harmless error analysis in that case?
I'm sorry?
Did they go into a harmless error analysis in the Brick case?
In Britt? No, Your Honor. But this is a case, I think, where you do not have to reach harmless error analysis because, in fact, this complaint was not preserved. And obviously, the purpose of the preservation requirement is to bring a problem to the attention of the trial court at a time when it can be corrected without having to go through the appellate process, send it back for a new trial.
Well, what the defense attorney said was, if I missed it, I apologize. I didn't hear the defendant not testifying, which was an inartful way, I guess, of saying, Judge, you didn't give a charge concerning the presumption of innocence and no negative inference to be drawn from a defendant not testifying. To which the court replied, it was in there. And counsel said, then no. So the court's response, it was in there, would seem to suggest that the court understood what counsel was referring to, and then the court, and then counsel saying that then no, which would seem to indicate, I guess, that he was withdrawing or she was withdrawing the objection?
So Judge, the way it was phrased, I mean, the whole reason, obviously, this is an issue is not because the trial court said, I'm not giving that instruction. The court intended to give the instruction, he wrote it down, he made a mistake. As people do when they think they've said something, the whole problem is he thought he said it. The way
But he didn't.
He didn't. But the way the defense attorney raised this, the sort of hesitant manner, almost as if I didn't quite hear it, I wasn't paying attention, is almost the equivalent. Not saying, Judge, you did not deliver that charge. Judge, I requested that charge. And when the judge says it was in there, she just backs off and says, then no.
Because the judge stated that it was in there. So, I mean, the judge says, yeah, I read that, it's in there. So should, at that point in time, why would the attorney not say, I don't think I heard it, or could you check? Or why would the judge not go back and check or ask for the reporter to check their notes to see whether it was read or was not read?
Well, Judge, that is what the attorney should have done. I mean, she basically makes a very equivocal statement, oh, I didn't hear this, maybe I'm wrong. The judge, obviously, again, the whole point of this is he's wrong, he didn't intend not to do it. She doesn't say, no, Judge, it wasn't in there. She doesn't say, can we ask, the 2 minutes of the court reporter looking at her notes would have resolved this issue. And again, this is not an issue.
So two wrongs make it right? So the judge was wrong, defense attorney was, well, incorrect. The defense attorney was incorrect, so therefore, we have no issue?
Well, Judge, again, the purpose of preservation is the defense attorney has to bring it to the attention, and I think that has to mean that you bring it to their attention in a way that they realize what you were saying. The factual premise of this could easily have been established. And this is not a case, and maybe the defense attorney has no reason to insist, because after all, if she's right that it's not in there, then this happens where we're on appeal. If she's not right, then
you're not really arguing that it was some tactical determination on the part of the defense attorney to just leave it and not pursue.
Not in this instance, Judge, but I think that is one of the issues that arises with preservation, which is why you have to make it clear what you're saying. And again, I just want to say, and I think the court is well aware of this, that this actually isn't a case where this conceivably prejudiced the defendant, because not only did the jury hear this twice, it was a very short trial, there was a weekend, they deliberate, nobody suggested the defendant could have testified. This evidence was simply overwhelming, they could see what happened. There's no reason why they would think the defendant should testify. And although, Your Honor, you mentioned the court not giving the presumption of innocence charge, the court, of course, did give the presumption of innocence charge a full charge about the burden being on the people, never shifting to the defendant. So there really is no possibility here that this had an effect on the verdict. And the equivocal manner in which the defense brought this up and then immediately retreated from it should lead to a conclusion that there's no preservation and there's no interest of justice reason to reverse this conviction. If there are no questions on any other matters, I will rest on our brief. Thank you.
Thank you.
I would like to just respond to a couple of points here. Again, I would like to just reiterate that this is it's a per se reversible error, so it does not matter, again, the amount of evidence that is at issue. Again, although it was a short trial, there was a lot of, it was 5 days, punctuated by a weekend. There was, again, it was a lot of evidence in the span of that. You cannot just assume that the jury remembered what was said at preliminary instructions by the time they entered the deliberation room, and that we cannot, again, this is a right against self-incrimination. This is a cornerstone of our criminal justice system, and that we cannot just assume that they may or may not have remembered this because this is such a cornerstone issue. And I would like to point the panel's attention to People v. Mark Jones, which is a court in which this court said that the trial court committed a per se reversible error when it inadvertently failed to instruct the jury to draw no inference from the defendant's silence at trial. And again, that's the respondent has admitted that the court failed to do it. It was a mistake. And there, it was an instance where it was clearly an oversight. So that is something that is instructive here, and we should just take note of. And then finally, there's no case that stands for the proposition that defense counsel must request a readback of instructions. And finally, I would just like to reiterate that it's important to look at the context here. And again, the trial court specifically requested the objections here. Defense counsel alerted the trial court to the objections, and his response was clear that he understood that what she was saying was that there was an insufficiency in the instructions in the form of an omission when he said it was in there. There's no need, the law of preservation doesn't require counsel to then take an adversarial posture, risk antagonizing the judge, and it doesn't require defense counsel to prove up again the court's error. She alerted him when she said it was in there. When she said, I didn't hear the defendant not testifying, and he unequivocally said it was in there. There was no need for further objections in the face of a clear articulation of the court's stance. Thank you for your time, and I rest on my briefs.
And also, you're doing this pro bono?
Yes.
So thank you, as well as Deborah Voice.
Yes, of course.
Thank you very much. Uh, 132nd versus Stewart.
Good afternoon. May it please the court. Christopher Ryan Clark on behalf of the appellants. Your Honors, this case comes before you in the context of a pre-answer motion to dismiss. And as set forth in our brief, manifest legal error was committed when the motion court ruled on a substantive affirmative defense in the context of a 3211A7 motion. Now, compounding that error, the court adjudicated certain legal issues, namely acting in concert on behalf of the appellants, as well as disregarding the corporate forms.
Let's focus on the actual causes of action. There's a cause of action for an equitable lien and unjust enrichment. How, as a matter of law, can there be a cause of action for an equitable lien when neither plaintiff has alleged that there was any type of agreement between either of the plaintiffs and defendant regarding a lien on the property, which is an essential component of an equitable lien cause of action?
Yes, Justice Kern. As the court sees from the background in the complaint, this case arose out of the transfer of the property to these appellants.
I understand the facts. So it's a very specific question. Why should that cause of action stand when one of the components of the cause of action is not alleged?
Your Honor, there are allegations in this complaint about how it was that the appellants came to own the property, including from Mr. Stewart.
But is there ever an allegation that he ever agreed that there would be some type of lien on the property?
Well, Your Honor, it stands to reason that when you convey a property, that if somebody goes and spends $500,000 to maintain the property, et cetera, it would be unconscionable to think that he hasn't profited from it.
You're using the word unconscionable, but the required component that seems to be missing is agreement. And I'll ask you a question about unjust enrichment, which has an unconscionability, but under equitable lien, there has to be an agreement. So what's the agreement that this defendant ever made with either of these plaintiffs?
Well, the agreement was that Mr. Stewart was going to convey title, Your Honor, which I know doesn't fit
That was already, the jury rejected that argument already. I mean, the jury has already said, no, there was no agreement to convey property, that he was defrauded. So that being the case, how could there be an agreement on his part to allow a lien?
Well, as the court sees in our brief, an equitable lien isn't just viable in the context of an explicit agreement. The court, under its plenary equitable powers, also has the ability to...
What's the implied agreement?
The implied agreement all has to do with the transfer of the real estate, Your Honor, because...
And we're back to the fact that there was a jury determination that there was fraud if there ever was any transfer, or any transfer was fraudulent.
Well, Justice Weber, that's correct. There was a jury determination as to that specific issue. However, that doesn't necessarily negate the ability to maintain an equitable claim. I point the court to the McGrath case. That's really the prism through which the court should analyze this case. And McGrath stands for the proposition that even when there's an adjudication of misconduct, the court still has to do a detailed factual analysis on the equities of the situation to determine whether an equitable claim is viable.
Right,
In
but
this,
separate apart from viability, there has to be some basis for an agreement, which you still haven't answered, but let's go on to unjust enrichment.
Yes, Your Honor.
And I agree, you need to break it out between the two defendants, two plaintiffs, because one of them, there was a jury verdict, it's a different analysis, but even as the one, 100 Street, where there wasn't a jury verdict, what is the relationship between 100 Street and defendant that would give rise to a claim for unjust enrichment, which requires some enhanced type of relationship?
That's correct, Justice Kernan. The real relationship here is that of grantor and grantee. Now, although it doesn't fit easily
That
because
doesn't fit at all with 100 Street because there's not even a claim that he even conveyed it to 100 Street. The
Right,
claim
it was
has to do with the other defendant.
It was the female, Charmaine Brown, who allegedly conveyed to 100.
that's correct. But again,
What's the relationship?
the relationship is that Mr. Stewart profited in the amount of over $500,000 based on
Right,
my
but
client's.
under the law, there's a very clear requirement for unjust enrichment that there be some type of enhanced relationship to say an unjust enrichment. So it's not just that he got a benefit, there has to be some relationship.
The relationship is through the ownership of the property. That's what brings everybody together in this instance.
You have to plead that there was a relationship between the parties that could have caused reliance or inducement. And I don't, where have you pled that? Where is that stated?
In the complaint, when it details the background of how it was that the appellants acquired some right, title, or interest to the property, that's what brings everybody into relationship. And based on that reliance, that's why my clients spent over $500,000 improving this property. Again, just to wrap up the point.
Thank you. You can continue on the rebuttal.
Thank you very much.
May it please the court, Stephen Wegg on behalf of the respondent. As was, I guess, pointed out a few moments ago, there are very critical elements of the causes of action that weren't pled in the complaint. I mean, at the end of the day, this was a complaint that was brought to intimidate the respondent from testifying in his own trial after his home of 55 years was
Well,
stolen.
that's your argument. I mean, you argue that in your papers. I see that. But again, you know, there was some indication that there was a transfer of the property from Mr. Stewart to at least 132nd Street.
Your Honor, fraud is an intentional tort. So if a party commits fraud, it can't then come and say, well, I thought that everything was okay, but it turns out I actually defrauded them. So that wouldn't work. An indication that there was some sort of legitimate transfer after a jury verdict finding an intentional tort, that wouldn't be an agreement. It would certainly actually be the opposite of an agreement because it would imply or would explicitly mean that there was
What about the argument that the two defendants can't be plaintiffs, cannot be lumped together, that they're in different situations vis-a-vis the defendant, because one there was a jury finding against and one there wasn't?
Well, Your Honor, the lower court properly found that they were both acting through the same sole principle. So even if it wasn't 100 Street that committed the actual fraud, there was no deed to 100 Street, everything that was done for 132nd was by the same principle that also claims ownership of the property through 100 Street. And we saw through the trial and the facts that were adduced at the trial that 100 Street played an integral part of the fraud.
Let me ask you, do you have an independent legal argument why these claims should be dismissed separate and apart as against 100 Street, separate and apart from the jury verdict against the other defendant?
Well, the complaint, first of all, doesn't state a cause of action. It misses elements. It misses
Well, it kind of lumps the two together. The complaint kind of puts the 100 Street and 132nd Street together, refers to them as one, right?
Well, legally they may not be one, but all signs point to them acting as one through the same principle. So it definitely groups them together as one. They were both appearing here through the same counsel. They were both represented by the same principle. They were both integral in the fraud that the jury found 132nd Street committed to steal the deed. So they certainly all work together, and it doesn't take even piercing to get to that. If there was a conspiracy to commit fraud in the prior lawsuit, I think certainly 100 would have at least been liable on that, but because it was really just to reverse the deed, it wasn't necessary against 100th Street, and the deed was obviously reversed. There's also the good faith requirement in an equitable lien, and that's in the Volovich case. You can't be a trespasser in the property. It's the old law school example. If I paint your garage red and then I give you a bill, do you owe me money? Of course not. You can't just come in and repair a property and assume, I'll come to you tomorrow and we'll put down an equitable lien. Or we'll come to you tomorrow and we'll say that I was you're unjustly enriched because while I claim to be in possession of the property, I performed whatever repairs, I paid whatever taxes there were, and at the end of the day, it seems that the two related plaintiffs in this case were actually part and parcel to one large fraud against the respondent. If there are no further questions, I'll rest on my brief.
Thank you.
Thank you, Your Honor.
It's important to realize that all of these arguments that are being made are made on the merits. There's a procedural difference of when there's a time to make merits arguments and there's a time to look at the facial sufficiency of a complaint. We're on a 3211 motion. The court created legal error by going beyond that and basically just trying to remember facts from an unrelated, from a different action. That trial transcript wasn't even before the court. When the respondents moved, they didn't submit that. Now, the idea that 100 was integral to the fraud, that belies the jury verdict in the Stewart action. 100 Corp. was found not liable. Moreover, its principal, Mr. McConney, was found not liable. So the trial court isn't just making these sua sponte legal determinations in the context of a pre-answer motion. It's actually supplanting its own the fact-finding by the jury in the related action. The jury rejected the notion that 100 Corp. And 132nd Street Corp. Acted in concert by not finding Mr. McConney liable and not finding 100 Street Corp. Not liable. And Justice Kern, as to your question about the relationship, I would just point the court to the Rock v. Rock case, which I understand is a Second Department case, but it does stand for the principle that in equity, the court has the power to find an equitable lien in a situation where there's no other cause of action that fits. It's similar to like a prima facie tort, where it's a tool that plays a lot of different roles. And in this situation, you have $500,000 that were spent improving this property. There's a time to decide whether or not it's equitable to grant a lien. It's not on a pre-answer motion. It's on summary judgment or on a trial. And because this was made on a pre-answer motion before any discovery had happened, the case should be remanded to Supreme Court for discovery and trial. Thank you.
Thank you. ULMI Holding versus Hillman. I just want to reiterate, I recognize that it's difficult to speak with the mask on, but the mask should be covering your nose as well as your mouth. These are not mouthpieces like boxers would wear, right? So cover your nose as well as your mouth. Thank you.
Good afternoon, Your Honors. My name is Fred Weinstein. I represent the appellant, ULM1 Holding Corp. The issue on this appeal is a very simple, straightforward issue. That issue is whether the guarantor revoked her guarantee, which she admittedly executed, and if she did, whether that revocation would serve to absolve her of the obligations that had been guaranteed prior to the claimed revocation. Now, the lower court correctly ruled that the November 30th letter agreement, which they refer to as an agreement, did not serve as a written revocation. And the law is very clear. In order to revoke a guarantee, you must make an unconditional, absolute, unqualified statement that you're revoking your guarantee. In that letter, the most notable thing is the guarantor doesn't use the word revocation, and the nature of the letter is it's aspirational. It's several days after she's executed an extension agreement of the lease term on behalf of the corporation, and she's reaffirmed her guarantee. She's saying at some point during the extension period, she wanted to transfer the guarantee to her son. who at some indeterminate point in time would take over the business and would succeed her as the guarantor. No mention of revocation, no specific time when she was intending to retire, no mechanism to have her son succeed her. And so the court correctly said, this is not only not the basis for a revocation, it can't be the basis for a binding agreement. It's just simply too vague and indeterminate. Where we think the court erred was once it made the correct determination, in our view, that this could not be enforced as a revocation or a binding agreement, it could not be a question of fact, as the court concluded, whether or not there was a revocation because the son allegedly delivered that same letter at the time or shortly before his mother moved out and said, "My mother is retiring." And that does not fulfill the requisites of an unconditional, unqualified statement of revocation. Obviously, he's supposedly delivering it. She's not. And he's not saying that it's revoked. He's simply saying, "My mother is retiring." And there's no dispute that he certainly didn't sign a new guarantee, nor did he take over the business. The facts are undisputed. She remained the president of the corporation. She verified her response to our complaint as the president of the corporation. And so very clearly, that letter that he delivered doesn't suddenly become the basis for an oral revocation, because if the court concluded correctly that it couldn't be enforced as a written revocation, the mere delivery of it, coupled with a statement, "My mother is retiring," doesn't solve the deficiency. It doesn't address, among other things, the other contingency that he take over the business and he sign a new guarantee.
Is there anything in the language of that letter which would suggest otherwise?
No, Your Honor. No. There is absolutely no, you won't see the word revocation. It's simply a statement, "I will retire within the term of the lease and at that time want to transfer the guarantor to my son, Sean Patrick Hillman, who is currently Executive Vice President of Corbin Hillman Communications and will take over as the president." So on its face, it doesn't meet the standard. And Your Honors, even if it did, there's an issue that the court below didn't address and that opposing counsel doesn't address in response to our brief. And that is that as a matter of law, once you've guaranteed obligations, as the guarantor did here, even if she had revoked the guarantee, it doesn't unravel the obligation that she assumed when she guaranteed the lease and any extension of the lease. The law is clear that it's one thing to revoke any obligations for extensions of the lease going forward, but it's an entirely different matter to say, well, yes, I guaranteed the extension agreement, but I'm revoking my guarantee, and that means from this point forward, even if there's a default under the terms of those obligations I guaranteed, I have no responsibility. The case law, which we've cited in our brief, makes it amply clear that once you guaranteed, as the guarantor did, the obligations of the lease and reaffirmed that guarantee in the additional space agreement and then reaffirmed it again in the extension agreement, she was guaranteeing performance for the entirety of that contract. And unless there was a statement in the guarantee that upon revocation, her obligations would end with respect to that extension agreement, it cannot be said under the terms of this agreement that any revocation would absolve her of those obligations. And so, Your Honor, I respectfully submit the decision below should be modified. Summary judgment should be granted in favor of the landlord against the guarantor, based on the breach. Thank you.
Thank you.
Good afternoon. Edward Weissman, attorney for respondent Hillman.
Counsel, let me ask a question. Opposing counsel is correct that this November letter never mentions the word revocation. It never suggests revocation. It's a pretty clear letter. And it says at some point, we want to transfer the guarantee if two conditions are met. If I retire and my son takes over as the CEO and president, at that point, we are going to request a transfer. How can that letter be any proof whatsoever of a revocation as opposed to a potential transfer in the future?
Judge, the Court of Appeals and this court have said many times that if parties get together and they may not draft the Magna Carta, but their intentions are known. It was her intention.
But where is there an intent in that letter, looking at the four corners of that letter, where is there any intent whatsoever about a potential revocation of the guarantee as opposed to a potential transfer of the guarantee?
Your Honor, the agreement was drafted by the plaintiff's vice president. My client is not a lawyer, and I don't believe the plaintiff's vice president was a lawyer.
So where is it implied anywhere in the agreement that the parties were talking about a revocation as opposed to a transfer?
Because she talks in terms of when I'm going to retire within the extension period. And if she's going to retire, it was fine with the parties. It was fine with Ms. Hillman, and it was fine with the plaintiff that that time would be determined at a later date. As a result, my client relied upon it, and for 7 years.
How could she rely on anything other, though? I mean, it's a pretty unambiguous letter. It says, when I retire and when my son takes over, you will agree to a transfer. And the landlord said, sure, I'll agree to a transfer at that time. How does that support any argument that there was ever an agreement of any sort to just a revocation by her as opposed to a transfer?
Your Honor, my argument is that the court erred in not enforcing it. But in the alternative, if there is any ambiguity as to what the parties intended.
What's the ambiguity?
The ambiguity is the when. When would it occur? And if that is an issue that parole evidence at trial will establish.
Why is there an ambiguity? Doesn't the letter say that a transfer, not a revocation, but a transfer will take place when I retire and when my son takes over as CEO and president? What's the ambiguity in that?
Your Honor, it's the non-use of the term revocation. My client doesn't use the word revocation, and neither did the plaintiff. But the intention of the parties
So you're saying
shines through.
the ambiguity is the failure to include the word revocation? That's not an ambiguity.
It may not be an ambiguity, but we know what the intention was in drafting that letter.
So
And by the way, it was drafted by the plaintiff.
So, counsel, let's talk about the intention. The intention, apparently from the writing, is that the transfer would take place when the son became the president. He never became the president, and he never signed any agreement of any time, at any time, agreeing, promising to assume the responsibilities of a guarantor.
Your Honor, they
Aren't those
never
conditions that had to be met? Didn't there have to be some type of performance in that way?
Your Honor, they never gave him a guarantee after his mother moved out. If they
Did he
didn't
ever
give,
become president?
yes, he took over from his mother. Yes,
When was
and it's not in the. He became the president. He took over the company.
He became the president and the CEO of the company?
He became the president of the company. Yes.
You didn't answer my question. He became the president and the CEO of the company?
I know he became the president of the company. Your Honor, if they're claiming they didn't even know about this agreement, how can they be misled by it? They benefited from it for 7 years until.
Counsel, you know, if you had submitted, your client had submitted to the landlord, hey, look, I want this transfer to take place. The conditions in this letter have been met. I've retired. My son has taken over. Let's do this new guarantee. Let's transfer it. But that isn't what happened.
Your Honor, in 2010, my client believed that she had taken care of the issue of her guarantee being revoked when she retired. They knew she
Well,
retired.
what evidence is there to support the argument that the landlord agreed to the revocation?
The landlord signed the letter. The landlord drafted the letter. You're holding it against my client that she relied upon the landlord to draft a letter that a lawyer would draft. We're talking about a situation.
Talking about a guarantee that's assumed by no one under your theory, counsel.
No, they never gave the son the guarantee to sign. And, Your Honor, my client actually went to the point of having another copy delivered prior to her move out. The landlord did nothing with it, never contacted Mr. Zemp, who drafted the agreement. The issue of whether there was an oral revocation is what this case is to go to trial on, because on that issue, if we're not allowed to use the writing, although the writing is the best evidence of what the parties intended, then we will offer testimony by Ms. Hillman and even Mr. Zemp, Dr. Zemp, to the effect that this is what the parties intended.
Thank you, Counselor.
Your Honors, there's a contradiction of some of the statements that were just made by counsel in this record. First of all, the guarantor testified at her deposition that she drafted the letter, which they're seeking to enforce as a binding agreement, and then sent it to Mr. Zemp, and they discussed it together. So the record does not support the idea that it was drafted by my client. But that's a red herring in any event, because this concept of ambiguity and needing a trial, that completely misses the point that the letter, no matter who drafted it, doesn't meet the requisites for either a revocation or a binding agreement. As was observed already, the word revocation doesn't appear. As the lower court noted, it is simply too vague. Retirement at an unspecified, indeterminate time, and absolutely no provision as to how there would be a succession with a new guarantor. So this is not a binding agreement. This is not something that requires a trial to figure out something that might be missing, because missing terms aren't the basis for a trial. This is not in the paradigm of ambiguity. Secondly, with regard to the statement that was made as to the idea that her son did take over, I note that that was not her testimony at her deposition, and as is reflected in the record, when she verified her answer, she identified herself as the president. And as the court observed, after she purported to have retired, he formed another corporation called Hill Corp, and it was through that corporation that he was paying the rent. So, and lastly, Your Honor, I didn't hear anything from counsel addressing the fact that as a matter of law, even if there had been a revocation, which there certainly was not, that would not absolve the guarantor of obligations she had already guaranteed, and she had guaranteed the lease and any extensions. Thank you, Your Honor.
Thank you. 1035 3rd Avenue versus,
I reserved, I think, 2 minutes.
I'll give you one.
Okay, I'll take it. Your Honor, what counsel just said is contrary to the law in this state for 100 years or more. According to counsel, if you guarantee an obligation, you're locked in forever. The fact of the matter is that a guarantee can be revoked.
Counsel, aren't you locked in until the lease ends?
No, no. It was modified by an agreement, be it in writing or be it oral, that when she moves out for retirement, that her guarantee obligation would cease. That's the oral revocation. The reason this agreement came about, this writing came about, was the result of conversations had between Ms. Hillman and Dr. Zemp, and that resulted in the writing. It was orally revoked if it was not revoked in writing.
Thank you so much, counsel.
Thank you.
Now 1035 3rd Avenue versus Pure Green, New York City.
May it please the court, I'm Randall Racy from the Barton Law Firm for the appellant, Pure Green, New York City, 62nd Street Corporation. There are two aspects to the order of Justice Freed in the court below dismissing her counterclaims. First, she decided to enforce the waiver of counterclaims and offsets provision of the party's commercial retail lease. And then she went ahead anyway to rule on the merits of the pleadings of the counterclaims and dismiss them all for failure to state a claim. We appeal from both aspects. With respect to the contractual waiver of counterclaims, I would point out that that's an interesting area because I would point out that every single case cited by Justice Freed in her order and by a landlord in their brief involves either a summary proceeding or a foreclosure
So let's
action.
let's look at the actual language, which is extremely, extremely broad. When you look at the language in the lease, it says that that counterclaim waiver provision applies in any action by the landlord for a default of the lease. It doesn't say in a summary proceeding or in a plenary proceeding. It says any action. And since this is clearly an action for a default on the lease, why wouldn't the counterclaim waiver be applicable in this action? Just based on the language of the lease.
The language of the counterclaim, the language you just read clearly supports the landlord and Justice Freed in this case. There's no argument. The issue is whether that's enforceable in this context.
Why
The
wouldn't
laws,
it be enforceable?
well,
What
because
about
the
a
laws,
plenary proceeding would make it unenforceable?
the law states, there are several cases stating, I'll quote from Daniel Luck v. Glasgow, which Justice Freed cited, which states that a claim of actual or constructive eviction and a commercial non-payment, that such claims are enforceable except counterclaims so inextricably intertwined with petitioner's claim that joint resolution of the claims will expedite disposition of the entire controversy, avoid multiplicity of lawsuits between the parties to accomplish the same result, to speedy justice for all and eliminate greater delay and expense.
How are they inexplicably intertwined there?
Because the counterclaims and the claim in chief all go to damages. The landlord already commenced and went through a summary proceeding to gain possession of the premises. And I'll add that they did that despite our client's efforts to negotiate a surrender.
Let me ask you, because it's not only that it waives all counterclaim, it also waives offsets. And since the landlord's action is one to collect rent, so even if you have a potential offset based on some other cause of action, isn't that what's explicitly barred by the lease provision again?
In our third counterclaim, we included as a claim for damages, I think, consequential damages, which may have been lost profits from failure to open the business. I would have to concede that section of damages wouldn't be inextricably intertwined with the landlord's claims. But the rest of it, particularly the first and second counterclaims, go directly to whether to the amount of money that our client would owe for damages. They interfered with, they went around our client and signed a lease at a lower rent with a replacement tenant, and now they're charging us for the difference. So that's directly intertwined.
Let me ask you a question on the merits as to that.
Sure.
Why it survives on the merits. Isn't it undisputed that at the time you wanted to effectuate this transfer, that your client was already in default under the lease?
Yes, that's true.
And doesn't the lease provide that if your client's in default, they cannot assign the lease?
It does. That's Article 14C of the lease. The issue there is we never got to the point where we're exercising our rights under Article 14. We never got to submit an application because they circumvented our client, who was working in good faith to mitigate their damages and the landlord's loss. And they signed up this same tenant at a lower rent, and then knowing that they could charge the difference against our client.
Thank you.
Good afternoon. May it please the court. Cheryl Ginsburg on behalf of the plaintiff respondent, 1035 3rd Avenue LLC. The lower court correctly dismissed all 3 counterclaims. As we just discussed, at the simplest level, the counterclaims are barred by paragraph 20G of the lease, which bars counterclaims. The claims are not inextricably intertwined. All of the case law on this issue generally holds that they're only intertwined when it's an issue of possession that is at play. And here, it's an issue of damages only. But even if that provision wasn't sufficient to warrant dismissal, as argued by the tenants, none of the claims meet the basic pleading requirements. The first counterclaim is for breach of lease. A breach of contract claim requires pleading 4 elements. The tenant here only pled 1 of the 4, just the existence of a contract. They did not plead their own compliance, they did not plead any damages, and they didn't plead a breach of lease by the landlord. In deciding this, the lower court correctly focused on the issue that the tenant had not pled its own compliance. As there was documentary evidence, a judgment from the landlord-tenant court was clear evidence that the tenant was in breach. They were in default of their monetary obligations under the lease. The tenant admits that it was in default of its monetary obligations at the time that it desired to assign the lease. Beyond that, the whole claim is speculative. To support its claim, the tenant only says it desired to negotiate. It didn't actually have a negotiated lease or assignment. It didn't even allege that it had somebody who was willing to take the terms that it desired. More importantly, no matter how tenant frames its claim, there is no right to assign the lease, and therefore no breach by the landlord. And most, tenant had a right to request consent to assignment. But paragraph 14 of the lease expressly states that if the tenant is in default under the monetary terms of the lease, the landlord has the right to reject that request.
I thought your adversary stated that they were in the process or making attempts to negotiate something.
Their whole claim is just that they desired to do it. They hadn't submitted a request at all. They hadn't submitted any paperwork to the landlord. They just said, we're thinking about it, is the essence of their claim.
But they're arguing that perhaps in equity, they're arguing that had you given them an opportunity to mitigate the damages, what they owe now, as the balance of their arrears would not have been so great.
Well, maybe had we given them an opportunity, but the landlord had the absolute right to reject it, even if we had given them the opportunity to negotiate that assignment. And also, the landlord did not stop the tenant from negotiating an assignment. We don't really know what was happening.
Profit? Stop?
Oh, right, they didn't stop, right. They didn't stop them from negotiating an assignment. And finally, with regard to the tortious interference with business relations claim, again, the tenant did not state a cause of action because they needed to allege that landlord's action was either for the sole purpose of harming the tenant or that the landlord interfered by means amounting to a crime or independent tort. They didn't make any such allegation. They actually alleged the opposite. They alleged that landlord was working to benefit its own financial interests. On that ground alone, the claim should have been dismissed. Unless the court has any further questions, I'll rest on my brief.
Thank you.
Thank you.
Just a couple of points, Your Honors. Regarding the Pure Green's negotiation with Fansco, the replacement tenant, this wasn't just a random party. Pure Green is, the parent company, Pure Green, licenses a right to operate under the Pure Green name, and they have recipes. It's not a franchise, but they have to license the parties to carry on the Pure Green business. That's what Fansco was doing. Our client was negotiating with Fansco to be licensed and to replace Pure Green and to operate the same business in that space. And that's what they did, even though the landlord had circumvented Pure Green and negotiated directly with the Fansco to take over the space for a lower rent. Pure Green still really had no choice but to continue to license them, otherwise they would be on the hook for the entire rent. I will be the first to admit that these counterclaims are not the most artfully pleaded claims that ever came out of our office, but the elements of claims are there. Regarding the tortious interference, we've alleged that the landlord purposely interfered with these relations, knowing that they could hurt our client by recovering the difference of the rent from our client under the lease. We don't have to show that there was no economic benefit to the landlord. I mean, every time there's a commercial relationship and someone does something wrong, it's usually because they think it benefits them financially. I think we've alleged sufficiently that they acted with an improper motive and engaged in wrongful, wrongful conduct. If the court has nothing else, I'll rest on our papers.
Thank you very much. Campbell versus New York City Department of Education.
May it please the court, Rudy Demasropian for the appellant, Pauline Campbell. There are really two main issues here that we want to address on this appeal that we believe the lower court got wrong. We agree with the lower court that the statute of limitation applicable to discrimination and retaliation case against the DOE is a one-year statute of limitation. We agree with that. Where we disagree with the lower court is the start time of the one-year statute of limitation. In this case, as we see from the termination letter that the city or the Department of Education copied or attached to their motion papers, is that she was terminated as not in her title. She was a cook at the time of termination. They terminated her allegedly based on a title that is a assistant chef or basically a lower title. They also terminated her during a time, or at least notified of the termination, she was on medical leave. Following the notice that she received of termination, there was a grievance that was initiated. It was not until November 6, 2017, when the grievance was concluded and the DOE upheld the termination, that we believe the one-year statute of limitation should have started. Because
So she was terminated on August 8, 2017, is that correct?
the effective date is August 8, 2017.
August 8, right. And then the action was commenced on November 6, 2018, is that correct?
That's correct, Joe.
So I thought you were also arguing that somehow that there was a tolling because of a complaint made with PERB. Is that also part of your argument?
That is part of the argument. I was getting to that, and I'll address it right now, Your Honor. There were two things that occurred around the time that she received that letter, which I believe was dated August 6th with an effective date of August 8th. There was a pending action with PERB. There was, as I said also a moment ago, there was a grievance that was filed through the union. Those two actions, or proceedings, I should say, could have at any point in time during those proceedings, up to and including November 6th, reversed the termination, which would have reinstated Ms. Campbell to her position. If Ms. Campbell was reinstated to her position, we believe that her termination was the adverse employment action in this case would have been moot. And if she does not suffer, or she did not suffer from an adverse employment action, she would not be able to bring a discrimination claim, which is one of the required elements of any prima facie case of discrimination or retaliation. So we believe November 6th should have been the start of the one-year statute of limitation. It should have been told to that time. We also believe that the November 6, 2017 final decision, as I refer to it, or confirmation of termination that came down on November 6, 2017, is an actionable event by itself. We cited to at least one case where it was held that the refusal to reinstate or rehire an employee after a layoff or suspension or termination by itself could be, under the proper circumstances, actionable. Here, the November 6th date, or decision, excuse me, came down about 3 or 4 days after she filed the notice of claim, raising all the issues of discrimination and retaliation. So we believe that by itself should also be an actionable event. And I'll quickly jump to the individual defendants.
Yeah, and could you jump first to Mr. Robinson, and please Where in the complaint are there any allegations as to Mr. Robinson?
There are numerous, well, there's at the very least one that comes to mind right now, and I'll refer to my papers for more details. I believe it's on page 44 in the record. Ms. Robinson states specifically to my client, "I'm a white supervisor, you're a black cook. Who do you think they will believe?"
No, I thought that's
I'm sorry.
O'Donnell.
The
That's
other one,
O'Donnell.
Well, I'm sorry, I didn't.
O'Donnell is,
Yes, okay, I'm
right,
sorry.
those statements were attributed to O'Donnell.
Robinson,
We're talking about Robinson.
Robinson, I'm sorry, Ms. Robinson was involved in refusal to assist any black employees, and I believe that was submitted, or at least in reliance on some of the signed statements by other individuals, non-party individuals, who have refused to assist black employees,
The
including.
question concerns Ms. Robinson.
What specifically did Ms. Robinson do?
What does the complaint say she did?
Well, Ms. Robinson was involved in assisting the act of Ms. O'Donnell to target Ms. Campbell. That was part of, Ms. Campbell was transferred from one school to the other. At some point, she was directly under Ms. Robinson as a manager. And we argue in the complaint that Ms. Robinson assisted Ms. O'Donnell in those actions. May I continue, or should I stop at this?
You can continue for 1 minute, I'll time you.
All right, real quick regarding Ms. O'Donnell, the lower court dismissed the claims against the individual defendants based on one position, which is that Ms. Campbell supposedly was not able or did not identify herself as part of two protected classes, age and race. The complaint specifically refers to Ms. Campbell as a black cook. So I believe that was an oversight on part of the lower court. But also under state and city law, we're not required to be over the age of 40 to be part of a protected class for age discrimination. She did claim in the complaint that younger employees and employees
How
with less
old
than
is she?
15 years.
Yeah, counsel, you can respond to that on rebuttal, I'm sorry.
Thank you, Your Honor.
Good afternoon. May it please the court. Eva Jerome from the City Law Department on behalf of the respondents.
What about the statute of limitations?
Yes, Your Honor. It is Campbell's burden to demonstrate that an exception to the running of the statute of limitation applies. Putting aside the fact that he never argued anything about PERB, the PERB complaint, or the appeal, the internal grievance in the complaint. No matter when you start the clock, there is no continuing violation. He cannot establish a continuing violation because of the length of time between the last uttered statement that was objectionable and the first act that falls within the 3-year statute of limitations. There are 3 gaps, 1 gap of 4 years, 1 gap of 2 years, and 1 gap of 1 year during the 9 years between the last statement. So the last statement in the complaint that's ever mentioned that has any indicia of racism or age bias was in 2009 at the very latest. The complaint was not filed until 2018. There is no joinder of any of the comments made to any of the acts that are facially neutral from 2015 onward. The change in the uniform, facially neutral. 3 colleagues being not being written up, facially neutral. Not having her own school, facially neutral. Her termination, there's nothing but conclusory language. There's absolutely no tie whatsoever, nor could there be under this court's holding in Brown and in Green, which found that fewer and shorter periods of time between alleged misconduct cut off the ability to bring in these stale claims.
Well, I thought there was also a claim for a hostile work environment, right? So that the overall treatment rose to this level of a pervasive, rose to this level of pervasiveness, discrimination against her.
Right. Well, for the very same reasons that the discrimination claims fail, that there's no allegation that any of the acts from 2015 forward, the sort of, quote, barrage of, the orchestration of the barrage of attacks that are alleged. First of all, there's no claim, there's no allegation that race or age played into the orchestration of these barrages from 2015 forward. And so the lack of any indicia of discrimination bars the hostile work environment claim.
Can you specifically address the allegations having to do with the individual O'Donnell and why those are not sufficient to allege hostile work environment and race discrimination?
Not sufficient to allege?
To allege hostile work environment and race discrimination.
Certainly, the last comment or quote or statement that O'Donnell is ever alleged to have said was at the latest 2009. Then we shift, we have a 4-year gap and we have a 2-year gap in which no misconduct is alleged whatsoever. And then we have this sort of 3 altercations that Ms. Campbell had with coworkers, which Campbell alleges were part of this, quote, orchestration. But there's the 3 disputes with her coworkers are facially neutral. There's no...
What about the statement referred to by opposing counsel?
That statement is abhorrent, but it is absolutely stale, and it's barred.
Wasn't it made within the last, after 2015?
No, absolutely not.
Wasn't there a statement made in 2017 to the effect, I'm a white supervisor and you're a black cook? Who do you think they'll believe?
That was not made in 2017. The complaint indicates that it was made at the latest in 2008.
Can you point out where in the record that supports what you're saying now?
Yes, just give me a moment, please. On appellant's brief, page 25 to 26, and page A32, if you put those 3 together, it indicates that the statement was made in 2007 because she refers to this additional person named Ms. Mizrahi, who was in the time period of 2007 that she admits. Campbell admits Mizrahi was in 2007. And so all of those statements are from that time frame. And that's on page 5 of our brief. The plaintiff took many liberties in placing statements that were from 9 years prior to the filing of the complaint, interspersed with conduct that occurred within the relevant 3-year statute of limitations.
Well, she claims that this was in 2017 because she states that it occurred, this statement made by O'Donnell, this statement allegedly made by O'Donnell was following a transfer.
Right.
And that transfer occurred in February of 2017, and that's when the statement was made to her by O'Donnell.
There are actually 2 transfers that Ms. Campbell experienced. One was in 2007, and it was as she was coming back to School 149 that when Ms. Mizrahi was a presence.
Was there a transfer in 2017 as well?
There was a transfer in 2017, but there's absolutely no comment in the record, in the complaint, that is from 2017. The transfer, the only comment was made regarding the 2017 transfer was that we were moving you because of safety reasons.
But my point is that she alleges that that statement was made by O'Donnell when plaintiff complained about a transfer, and that transfer was in February of 2017. So you are stating that there was a transfer in 2017.
Yes, there was.
So it is not, therefore, the record, therefore, would not necessarily not support her statement that the statement by O'Donnell was made in 2017 and not in 2014. Is that correct?
2007, actually. The first transfer from that far long ago. But yes, I believe I'm answering your question, that the complaint, in the other parts of the complaint, if you read them, make clear that the reference statement was made to Ms. Mizrahi, who was only a fixture in the 2007 transfer, not the 2017 transfer.
Okay, thank you.
Thank you.
Counsel, can you address that particular issue about when the statement, alleged statement by Ms. Campbell was made about?
Yes, Your Honor. There were two transfers. The alleged statement, as reported by my client, was done after the second transfer, not the first transfer. But I would also add on that point, Your Honor, that we're dealing here with, even though we do understand how the statute of limitation functions, but the continuous violation, we believe, should apply in this situation. We went intentionally back to the year 2005 in the complaint to list several pages of numerous specific examples of what we believe to be acts of discrimination and retaliation and harassment, but also we were luckily, I would say, able to supplement the complaint with specific signed statements by non-party witnesses who confirmed that Ms. O'Donnell was targeting black employees, was requesting and directing other employees to instigate or start a fight or an argument with Ms. Campbell. So that was an ongoing basis. These were not just one incident in passing. This was a routine daily thing, or I would say continuous thing, that was occurring at the job. The specific examples are one thing, but the statements confirmed that this was an ongoing matter.
So, counsel, there was also a question concerning your claim for some type of age discrimination. Where in the complaint do you allege either your client's age and the ages of those coworkers whom she states were paid more than her?
The complaint does not specify either my client's date of birth or specific age at the time of the events or the time of the complaint being filed. The complaint states that younger employees, but also states that employees with 15 years or more on the job were being targeted. And there were specific allegations that she was getting paid less than employees with less seniority, that she was miscoded compared to younger employees. As I was mentioning very briefly earlier, we don't believe under state law we need to specify the exact age, but as long as we specify that the plaintiff was being targeted or treated adversely because of her or his age, and in this case, we believe we made sufficient allegations to support the age discrimination claim.
At least, would you be required at least to state an age?
Well, on the federal law, it's 40 and above protected class. On the state or city, it's not. We didn't believe at the time we drafted the complaint that specifying the age would be a necessary requirement, as long as specific allegations were
So
being...
she's 37. I don't know how old she is. She's 37, she's 35, she's 22. I mean, I don't know. I would think that the complaint should state some age,
Well,
at least her client's age.
it would be helpful to actually put the puzzle together, but I don't think it's necessary for the claim of age
Put the
discrimination.
puzzle together, it'd be helpful to determine whether there's any age discrimination. But anyhow, thank you so much.
Thank you, Your Honor.
Interesting.
Silverstein versus Telestock.
May it please the court, my name is Barbara Burke Silverstein. I was admitted to practice law in the state as Barbara Burke, my maiden name, in 1983. I worked as an attorney in this state until 2007, when I had to go on permanent disability because of medical malpractice committed upon me by a doctor at Mount Sinai Hospital. My trial attorney, Gary Pillersdorf, did not prepare me to testify at the trial. He did not prepare a damages case. He had no discussions with me about any of the surgeries I underwent, which was at least 12 by that time. He didn't discuss my day-to-day activities, which at that point were basically spending half my day in the bathroom and the rest of the day spending the day in bed in horrible pain, having to take pain medication around the clock. I had to have an intrathecal morphine pump put in my body because I couldn't do other pain relief procedures. That pump made me lose production of my saliva. I then developed fungus in my mouth and sores, which prevented me from eating normally without putting lidocaine on my tongue. And it took 2 years for the fungus in my mouth to go away. I now have the same fungus, Candida, in my esophagus, which was diagnosed in 2019 because I have not produced saliva since 2009. I cannot take the medication that one would take to get rid of this on a temporary basis because it caused my fingers to peel and bleed. The other medications are more noxious. I have rashes from medications. I'm the person that gets the strange side effects to medication. They gave me medication to help me produce saliva. It caused me night blindness in my right eye for 10 years. Thank goodness, after 10 years, it disappeared. I went from being an appellate attorney sitting at a computer 7 hours a day to spending between 5 to 7 and upwards of hours a day in the bathroom because I have bowel dysfunction. Gary Pillersdorf did not speak to me about any of this. He did not consult the proper experts. He ignored the fact that my son was suffering from depression. He ignored the fact that my son was born through a donor egg process, and that now my son is in graduate school years later. He was 6 at the time of the hysterectomy in 2005. He's in graduate school, and he suffers from severe depression. I get phone calls from him. He got a 2-year all-paid MA to Indiana University for Jewish studies, and he had planned on going to get his PhD to be a professor at a college, but he doesn't know if he can focus and do this work. He has no memory of my ever not being in pain. He had to come see me in the hospital when I had the emergency surgery 4 weeks after Dr. Najat's surgery. All he saw was mommy in the bathroom, mommy in the bathroom, mommy cannot go do things with you anymore. Daddy has to take you places. Daddy has to take you on vacation. How do I tell a person I'm trying to date what I do all day? How can I have a life other than sitting in my apartment in the bathroom, and I can't go out till 4 or 5 o'clock in the day by the time I'm finished going to the bathroom and have enough pain medication in me so that I can possibly try to go to a walk so I don't get blood clots in my legs. I haven't been able to work since 2007 due to the severe pain and throbbing I developed because of the nerve damage in my pelvis due to the surgery that Dr. Najat performed, which was unconsented to. And Gary Pillersdorf completely ignored all of the evidence in my favor and agreed with the defendants. He let the defendant's lawyer get away with violating Judiciary Law 487 by engaging in deceit and collusion with the surgeon and their experts to protect Mount Sinai Hospital from having to pay a verdict to me based upon its negligent hiring of Dr. Najat. I will rely on my papers for the rest of my argument. Thank you very much.
Thank you so much. For Kofka versus Applied Projects.
Good afternoon, Your Honors. My name is Judy Shametzi. I'm with Wilson Alster for the appellants, and I'm here to respectfully request that this court reverse the granting of summary judgment in the plaintiff's favor because questions of fact remain about 3 issues, really. Whether the plaintiff was supposed to clean the area that would have allowed him to take the hillside up to the top of the incline where he was supposed to work, and walk, and that's question 2, whether he was supposed to walk that incline as opposed to taking the retaining wall. And also there's a question.
That he was supposed to clean the area.
I'm sorry, Your Honor?
What's the area that he was supposed to clean the hillside next to the
So
retaining?
he's saying that he couldn't walk the hillside for two reasons, because there was debris on it and there was snow that was so deep that it got into
But
his.
what's the evidence that that was part of his job as an iron worker to clear the hill of either debris or snow?
So on page 132 of the record, he testified that where there was interference with his company's job, such as snow, he and everybody else with his group would clear
But
whatever.
why, assuming that's true, why did he need to clear the snow to do the work on the retaining wall?
Well, it's exactly the same scenario as what happened with the container, which is the testimony I'm referring to on 132. They needed a container to do whatever it was that they were doing. The snow was in the way of the container, and he said whether or not it's our job to clean snow, the reality is, in order to do our job, we needed to get this done, and so I did it.
Why did he need to leave the retaining wall and walk on the hillside to do his job?
He doesn't need to leave, no. So he doesn't need to be on the retaining wall at all. This is the question of fact, right? Is whether he ever really needed to be on the retaining wall. Where he needs to be is at the top of the hill to take panels to put basically onto the wall, onto poles that are already stuck into the wall. So
Let me rephrase the question. What was improper about him being on the retaining wall to do this work as opposed to cleaning snow and debris from the hillside?
Well, the retaining wall itself is covered in ice and snow. It's not meant, it's a wall. It's not meant for walking on. He chooses to take the wall because it's easier than to take the hillside.
Wasn't that routinely done at the construction site, though?
I'm sorry, Your Honor, one more time.
Wasn't that routinely done at the construction site?
This was their first time up and down this hill.
Counsel, didn't Mr. Colleran, applied site safety manager, testify that there was snow and debris under the snow preceding Yahoo's work at the site? And didn't Mr. Colleran also testify that Yahoo was responsible only for the area where it worked, and it was his responsibility to make sure that there was no debris that could injure any employees or anyone else?
That's, if I can take the first part first.
Sure.
With respect to there being, yes, there was debris. This is like old trash. It's an old trashy
So
hillside.
I piggyback on my colleague's question. Why would an iron worker have to pick up old trash?
Because he has to pass there.
Huh?
Because he has to pass there. He testified with it, Your Honor. All I'm saying is that there is a question of fact, because as the non-movement, I believe we are entitled to the favorable inference from that first set of testimony having to do with the container, right? The testimony is, we needed to get this thing done. The snow was in the way. Obviously, we cleared the snow. That's his testimony.
But he said it was only on one occasion that he said
Yeah,
it was
because he didn't
one-
do it. I'm
One
sorry.
occasion, yeah, but one occasion and he had done it. It does not mean that that was his job to do it.
What he testified to, it was his job to do what they needed to do to get the job done, which in the first instance was to clear the area for the container. In the second instance, it would have been to allow them to get up to the hillside without climbing a wall.
So they should have cleaned up all of the debris in the hill. Is that what you're
I don't
saying?
know that all of it would have been necessary, but certainly if he feels that he cannot pass, and it's not just the debris, by the way, it's also the snow. He's saying it's no good for his boots.
Well, the thing is that they don't know what's under the snow.
I'm sorry, Your Honor?
They don't know what's under the snow.
Oh, of course, I'm not disputing that at all. All I'm saying is there's a question of fact, given the inference that is unavoidable from his testimony, that when there's something needed to get done in order for them to do their job, he took care of it, including shovel snow. This is a scenario that is exactly like that in a different area of the same job site, and therefore I'm saying as the non-movement entitled to the favorable inferences, that is a fair inference to make, and it warrants denial of the plaintiff's motion for question of fact.
Thank you.
Thank you, Your Honors.
Good afternoon. May it please the court, James Scafidi on behalf of the respondent.
Is Mr. Hovorka's, is it his duty to clean up whatever's on that hill?
No, Your Honor, it's not. So he is an iron worker. His job was, this is if I may back up a second. Dyer Avenue is a substation. Substation powers the trains that go through. So the 5 train runs there, goes to Dyer Avenue, Eastchester Avenue. There is no train there, okay? So they're refurbishing the entire substation. So there are numerous contractors everywhere. Yabu was specifically hired to remove and install fencing. That was his job. He's an iron worker. There are 3 laborers that work for the company, okay? Joe Ryder, I think his name was Joe Lima, and then there was another Mr. Lima that was working on the site. Mr. Havorka would only remove snow when he was asked to do it. He was asked one time to do it, and that was to put in a container so that debris from Yabu could be put in that container. But I would just like to back up because we're talking about removing snow and ice, but this case really comes down to 4 items. I mean, it's undisputed that where he was at the time of his accident, he was 6 to 8 feet above the ground on the slope of a retaining wall. And counsel wants to say that the retaining wall is not part of the job site. I respectfully disagree. I would point to pages 4 and 5 of her brief, which she conceded was part of her job, was part of his job. I would talk about the SAR report, which is the Supervisor Advisory Inspection Report. I would also talk about the fact that Mr. Havorka himself testified on page 143 of the record that he was going up there to hang panels on the retaining wall. So the retaining wall was definitely within the scope of his job. He's an iron worker who was subject to an elevation-related risk. He was with his foreman at the time. His foreman never instructed him to remove snow, ice, or debris on the hill, okay? So I would just like to quote this court when I say, Justices Weber and Gonzalez in Placu versus 1622 Van Buren, which was decided about 2 weeks ago, said a plaintiff's comparative negligence is not a defense. So we're talking about removing of snow, ice, and debris. That would be, in my opinion, comparative negligence. Where there's an issue here is he was supposed to be given a safety harness and a safety line. The appellant's witness concedes that fact, and he wasn't given one. He wasn't instructed to wear one. He was at a height. He slipped on the slope of retaining wall, which was 6 to 8 feet above the ground. This case is very similar to Striegel versus Hillcrest, where a plaintiff was working on top of a roof, and the pitch of the roof in combination with ice, which he slipped on, caused him to slide from the top of the roof down to the bottom of the roof. He didn't fall off the roof, but he still injured himself. 240 subsection 1 applied, and he was entitled to recover. In addition, there's case law that this court is aware of. We talk about, just one second, Justices Kern, Gonzalez, and Shulman and Ging versus FJ Giam Construction Company, that a plaintiff can recover under 240 if he or she is injured by a gravity-related accident, even if he or she did not actually fall. One of the arguments that they make is that it wasn't a significant elevated height. Doesn't matter whether it's not. To the left, to his right was 6 to 8 feet fall down. Testimony is, I was stepping with my right foot. I was going towards a post. I went to reach to grab the post. I started to lose my balance, and then instead of falling to the right, I instinctively bailed to the left onto the hill, where I cut my left wrist, severed my left median nerve, which is the eye of the hand, essentially controls the thumb, index, and middle finger. He now has really no use of that hand, and the gentleman was 21 years old at the time. If there are no further questions, I will rely on the rest of my brief.
Thank you.
Your Honors, it has never been my argument that the wall was not part of the job site. Of course, the wall is at the job site. The question is he supposed to be on it? He's supposed to put fencing on the wall, but he himself is not supposed to be on the wall. That's my arguably, he is not supposed to be on the wall because he has an alternative.
How would you put the fencing around the wall if you're not on the wall?
I'm sorry, Your Honor.
How do you put the fencing around the wall if you're not on the wall?
The wall is only, like a foot wide. So and it's not very tall. It's a retaining wall. So the idea is that it has poles. They lift the fence that goes onto the pole. You can stand, if I were putting something on here, Your Honor, I can stand and bolt it without standing on the lectern. In fact, I'm not even sure you could do it if you were standing on the wall. So That's that part of it.
You're an expert on putting up fencing.
Only since this, but I learned quickly.
No, you're an expert in many capacities, so I thought maybe you were also an expert fencer.
I mean, I've been known to install things at home, but not very.
Yeah, I know.
I did want to just, for the record, I don't know what case counsel just cited. That was 2 weeks ago. He had not exchanged it with me prior to argument, so I can't possibly comment on that. But with respect to the comparative argument point, the comparative negligence point, my argument is that there is a question of fact about whether it was his job to do it. And again, I'm not going to go over it again, but I think it's a fair inference from the container situation that if something was in the way, it was his job to clear it. Other than that, I will rest on my brief, Your Honors.
Thank you.
Thank you.
Yanez versus City of New York. Yanez, I'm sorry. I said Yanez.
Good afternoon. May it please the court, Mackenzie Phillip for the Department of Education. This court should set aside the verdict because it is excessive when compared to the awards approved in similar severe burn cases. Appellate division precedent sets a range of reasonable compensation for severe burns from $3.6 to $16 million. And the only question here is where exactly in that range this case falls. The facts show—
So, counsel, you don't see this case as unique?
It is sadly not unique.
It is not unique. There's prior cases involving a 16-year-old burnt in a high school experiment where 51% of his body is burned.
Actually, only 31%.
31% and the other 20% skin grafts, right? So he loses 51% of his body surface. He has debridements in the morning. He has procedures in the afternoon to put the grafts on. He has, I mean, I could go through the litany that was outlined in the 38-page written by the trial judge, affirming the jury award.
It is undeniably tragic, but sadly, these are the sufferings of every single person who suffers a severe burn.
In this magnitude, at this age, with a 54-year-old, with a 54-year life expectancy.
Yes, in fact, we have the case of Lee.
Did Lee have to undergo 120 procedures?
I'm not sure exactly how many procedures he had, but Giannis had 5 surgeries, and Lee had 7 at the time of trial and still needed 5 more. If you look at the facts of Lee,
Giannis had more than 2,000 staples put into him as a result of the surgeries, had skin removed from his scalp, and had to wear a compression suit. Let's see.
Lee had all of those.
What else did he have, counsel?
Lee, just like Giannis, Lee had to wear compression garments for a year at least. They both wore a neck brace. Lee also required chest plates. Giannis lost his ears. Lee lost his ears plus 2 fingers, a nipple, and his belly button.
Giannis was degloved. Are we going to go one-on-one on this?
Yeah, counsel, I don't think this is going to
Really?
work. I really don't. And I find it to be a little bit disconcerting that you would actually make the argument that the horrific injuries that this 16-year-old suffered are in any way comparable to those sustained by Lee. So I think you should just get to your point in terms of what you believe what you believe we should do.
Our position is that the court should set aside the verdict unless the plaintiff agrees to a serious reduction in line with what—
What was your position at trial, by the way, in terms of what the damages should be?
I'm not sure if we presented a specific number. I don't know if that—
Did you present any evidence to rebut the evidence that was presented by plaintiff on damages?
I don't think we did, but the point here is not that he didn't suffer. That's, to be clear, everyone agrees that Giannis suffered terribly. The question is whether $59 million, which is dramatically more than any pain and suffering award that this court has ever affirmed is appropriate in this case, where there are people who have suffered much more extensive burns who got way less. The point of 5501 is that this court needs to take a step back and look at this case compared to other severe burn cases. The jury didn't have that opportunity, and it's not the jury's role, in fact, to do that. The legislature directed this court to stop runaway jury verdicts. It thought the legislature considered putting a cap, and instead it chose this more flexible.
But in Reed, the First Department said in 2003 that personal injury awards, especially those for pain and suffering, are subjective opinions, which are formulated without the availability or guidance of precise mathematical quantification. So here the jury sees and listens and observes.
Sure.
The plaintiff and everyone who testifies on both sides, on the behalf of both sides. And here you have a judge who says, I'm not setting aside this verdict.
Yes, the judge actually made a serious legal error. He seemed to think that he had no power to set aside the verdict. That is plainly wrong.
I think you're mischaracterizing the opinion.
He said, I believe he said something like the role of the jury is to decide the damages. It would be unconstitutional for me to set them aside. That is incorrect. But even if he decided not to do it, the point is that the legislature directed this court to set aside these enormous verdicts to ensure that similar plaintiffs receive similar awards. And that is not happening here. What happened is that Lee got a $5 million award.
But Lee was not a jury case, was it? Wasn't it a court of claims case?
It was, but this court...
So you didn't have a jury evaluating the evidence in that case and determining that $5 million was actually reasonable compensation for someone with those injuries. That was not a jury that did it.
The same standard applies in cases that go before a bench trial as in a jury trial. And when you compare this case to Pete, its excessiveness is even more obvious. Pete was burned on 50% of his body, and his damages were dwarfed by the enormous award here. The legislature directed this court.
How old was Pete at the time of the injury?
Pete was 37, but even if you look out, if you do the math and see, the jury says how long they expect him to live. And if you look at it per year, for example, for future damages, Pete's award is $187,000 per year.
So this young man is expected to live another 54 years with these horrifying injuries, right?
Sure, but the 20-age difference, isn't there? A 20-year difference between Pete and Giannis?
Yes, but if you look at the per year award, that's what I'm saying actually. So Pete's future award was for 32 years. It was $187,000 per year. Giannis's is for 54. It's $547,000.
At the same level as the pain and suffering of a 16-year-old?
I have the record here with the photographs of Pete. It's worth looking at these photographs to see what Pete went through and compare them to what Giannis went through here. This is what the job of the court is to compare the two cases and see where does Giannis's case fall on the range of this court's past precedent. Pete suffered enormously. His burns were on 50% of his body. He lost body parts just as Giannis did. Even though he was older, the court can do the math, and it's very clear that Pete's award is tiny compared to Giannis's. And the point of this court is to make sure that plaintiffs who suffer similar injuries receive similar awards. And that's why this court needs to set aside the verdict order if the plaintiff won't agree to reduce it. I'll save my time. Thank you.
May it please the court, good afternoon. My name is Ben Rabinowitz. I represent Alonzo Giannis and his family.
So this award is substantially larger than any other award. And again, if you put it in the context of Pete as well as with Lee, it's far, far more.
If I may, Judge Weber, thank you for the question. There is one major distinction with this case than any other case. Alonzo Giannis lost his entire face and ears. In fact, every square inch of his face and head was either burned off or surgically removed. Not one of the other cases, whether it's Weigel, Susan Weigel didn't have an injury to her face. Christopher Pete, had no injury to his face, and I agree with counsel. I would like you to see the photos. I actually have them here so that you can take a look at them if you'd like to compare them. I have photos of Alonzo Llanes, 10 of them that are representative, because the scanning doesn't accurately portray what Judge Tisch saw in the courtroom. And I'd ask you to please take a look at them. I could refer you directly to the record. Not one other case, whether it's Lee, whether it's Niesel, none of those cases did the plaintiff lose his face. This is a 16-year-old child. Not only did he lose his face, but what wasn't mentioned by counsel is that he suffered methanol toxicity to his kidneys, to his lungs, to his trachea, to his larynx. He actually had degloving injuries to both hands where all of the skin was removed. He had 2,000 staples and more trying to hold the cadaver skin, the dead skin that was affixed to his face. And then he suffered something that none of the others had, which was methicillin-resistant Staph aureus, flesh-eating bacteria that destroyed the cadaver grafts, and it had to be removed, surgically taken away. These are operative procedures.
Well, counsel made reference to the fact, I think that Pete, I forget, there were more surgeries in that case than there was in Llanes's case.
So I thank you for that question as well. Nothing could be further from the truth. Dr. Yurt, who testified, and the city chose not to even bring in one witness, as Your Honor so carefully pointed out, Judge Mendez, there were over 120 surgeries. We're not talking about simple debridements like a Band-Aid. They actually removed his ears in pieces. They actually scraped away his entire face, his entire head. If you take a look at the record specifically, and I go to the appendix 2513, 2519, and 2522, you'll see every square inch of his face. There is no case like this. This case is a complete and total outlier. No case have I ever stood before you, and I've argued, for example, in Aguilar, where there have been 9 surgeries or 10 surgeries. We're talking about 120 surgeries. Very much, Your Honor, you decided the 91st Street crane collapse, and in that case, you actually spoke about how different it was than the others, and you spoke to us and provided guidance for us to teach with the other lawyers, and I've done that. And so have you, Judge Mendez, when you actually cited it being the trial court judge in that case, how different it was, and why it requires a variance. So what I did was I did an apples-to-apples comparison. If you take a look at the Susan Weigel case, which the city improperly cited as being a 2013 case, it's a 2003 case, and it's a case where the verdict was in 2001. 17% of her body was burned. She required 2 skin grafts, and they awarded $8 million. If you do the extrapolation, and you show the extrapolation for both the percentage of skin burned and the number of years, the verdict would have come out to, if we actually add for Alonzo Llanes, it would be $40,909,000. That's an exact number, taking into account inflation, taking into account if you use the U.S. Bureau of Labor and Statistics calculator for inflation.
So, counsel, you're arguing that the hard number should not be used if one is to look at this in a formulaic manner, but rather that the number should be increased or decreased according to what?
I'm saying this. The reason Weigel, even if it's $40 million on an apples-to-apples comparison, she didn't lose his face. Alonzo Llanes can't walk down the street, and he'll never be able to walk down the street for 54 more years, where we know the injuries will be 2 to 3 times worse, because that's what Dr. Yurt, not a courtroom testifier, the head of the Cornell burn unit, who came in and said, it's going to get 2 to 3 times worse in the future. She didn't lose her face. None of the others lost their face. None of the others lost their identity. This case is unique. Just as you said, Your Honor, I couldn't agree with you more. That's why this case stands on its own. There is no case like this. There is no case where a 16-year-old child lost his face, lost his identity. There is no case where that child had 120 surgeries, and we know that because of the contractures, his head is being pulled down. He's going to have spinal injuries. The city, they're very smart lawyers. They chose not to present any damages witness. None. None whatsoever. Judge Kern, in your case, in the Hackstraw case, you actually said specifically, and we taught with this as well, you actually said specifically that we should inquire, why is it that the juries in New York County are awarding numbers that are greater? Because they're based on reason. And here we're saying the city of New York hasn't shown you that this verdict materially deviates. It's not a runaway jury. It's not a runaway trial judge. Judge Tisch saw it. He felt it. He examined it. He carefully scrutinized it in his 38-page decision. That's why this case is such an outlier, just like the 91st Street crane collapse. It's an outlier. But there is no case you can point to where a 16-year-old child lost his face having been an innocent victim when they didn't even bring in the most rudimentary, fundamental safety devices into that classroom. No fire blankets, no goggles, no showers. They couldn't even wash him off. The city says he was burning for a number of seconds. Not true. He burned for 57 minutes. I have the record, page 8, 2579. It says it specifically. The methanol wasn't rinsed off. It continued to burn him until he was in the treatment room in the hospital because they didn't have showers in the classroom. And we learned at trial they didn't have showers in the school altogether. Yet the teacher brings in a gallon of fuel and pours it across an open flame, burning off this child's face.
And counsel, you're speaking of chemical showers, right?
Yes, exactly,
Not regular
Your Honor.
water showers.
They didn't even have water showers, Judge. They didn't have anything to rinse them off. Water would have been good. It could have at least taken some of the chemical off. They didn't have water showers. They had nothing there. They didn't even know of the existence of the science safety manual. That's why this was so wrong. But Judge Tisch carefully, excruciatingly, in his 38-page decision, showed why there are no comparable cases. And there are no comparable cases to what happened here. What happened to the 16-year-old child is something he's going to have to live with every day for the rest of his life. He doesn't have a vacation from this. He doesn't have a holiday. He can't get away from it. When you walk down the street with him, people go, "Oh my God, what happened to you?" He'll live with that for the rest of his life because of what happened. His face is gone. There isn't one other burn case where someone's face is gone, where their identity has been taken. This case is unlike any other case. That's why I say it truly is an outlier. It's a one-of-a-kind case. And for the city to come in here and say that the Pete case suggests that type of number, no. Christopher Pete was twice as old. The more recent cases, for example, Marion Hedges, argued by Matt Geyer, a wonderful lawyer, or Ben Morelli when he argued the Perez case, Mark Perez. We're not dealing with a 16-year-old. Each of them was 2 to 3 times older. Marion Hedges was 46 years old at the time. We're talking about a lifetime of pain and suffering every single day where he can't even walk outside. It's almost Halloween right now. And we know what happened when he went back to school. The kids taunted him and said, "Nice mask, Alonzo." The cruelty of kids, which you know about better than anyone. He wasn't even wearing a mask. This is what he has to go through. And now we know that adults who actually see him, they back away from him. Oh, what happened? Every day, this is what he's dealing with. This is so unfair for this child. This is a one-off case, a one-of-a-kind case. That's why what Judge Tisch did in carefully analyzing this speaks to the volumes of justice. I urge you, please take a look at the photographs. Take a look at what happened to this young child. I'm afraid to sit down because I'm fighting for the life of this young child.
Thank you, counsel.
Thank you, Your Honors.
I really would ask the court to take a copy of the Pete record and the Lee record, which I have both here, because they do show that the faces of both of those plaintiffs were severely burned. There are photos in the Pete record. His lips, his nose, his ears, his eyes, they were all burned. Lee as well. Lee lost his ears as well. There is no, and my colleague here focuses on things that happened at the liability stage. That is really not at issue here anymore. And the reason he's focusing on that is because there is no legitimate way to distinguish these cases. It cannot be claimed that Yanez's situation was as severe as Pete. After 2 weeks in the hospital, Yanez could walk. After 6 weeks, he could do yoga. After 10 weeks, Pete could not even roll over in bed.
Please, please, don't tell me he could do yoga. Please.
The record just it's just to show what he could do. The point.
Spent 2 months in the regular hospital, to the point that the doctor there became his treating physician at Weill Cornell, and then he went to the Children's Hospital for 3 months.
Yes, Pete also was.
counsel, we know this record, and you can't minimize it. You can't minimize
The
it.
fact that someone can do yoga when they have lost their face and they are severely deformed, it doesn't mean that, that the injury is any less because they can do yoga.
I apologize, it seems to have bothered you that I mentioned this. I did not.
No, it doesn't bother me. I just find it, to some extent, I find it insulting to say that the person can do yoga. I mean, that is minimizing the injury.
I'm not trying to minimize the injury. What I'm trying to show is that the injuries of the other plaintiffs in the other severe burn
Could they do yoga as well?
also.
Are you going to tell me they could do yoga as well?
No, the point is that Pete couldn't even roll over in bed after 10 weeks in the hospital. His injuries were more severe. His pain and suffering was
Thank you, counsel. Your time is up. Thank you very much. Thank you both. Chen versus New York Hospital Medical Center of Queens, et al.
Good afternoon, Your Honors. May it please the Court. Saul Kotze appearing for Appellant Chen. I know the record is kind of lengthy in this case, Your Honors. I wanted to sort of condense it to the main issues here. The lower court dismissed the action against Dr. Moody, finding that the statute of limitations had run against her. However, if you look at the decision on the last page of the lower court's decision, the court actually found that the action was timely when the amended complaint was filed against Dr. Moody on September 4th, 2018.
Yeah, but Dr. Moody didn't get notice of this until June of 2019, and the actual notice of this complaint was after the wrongful death period expired in August of 2018, and after the medical malpractice case expired in February of 2019. Notwithstanding that you were timely within the 60 days as granted to you by Judge Rackauer below. So that timely filing, it may be accurate, but in terms of bigger picture, you would concede that notice of this was 6 years after the initial insult, so to speak, and alleged insult, and after the applicable statute of limitations. Would you agree to that?
Well, I think, Your Honor, there was a number of factors that play into this. One was, and these were all barriers and roadblocks, not of the creation of plaintiff. One was Mr. Chen's cognitive and physical impairment following the procedure until he passed away.
But I thought that there was an extension that was granted based upon that.
There was, well, Mr. Chen was entitled to the insanity toll of CPLR 208, and that is the insanity toll that the lower court applied when it calculated the statute of limitations. The court found that the toll applied until February 4, 2019. The amended complaint, well, initially the complaint listed John Doe, and that was the other factor that was sort of complicated was when the records came from the hospital, the anesthesiology report was not included. So there was an issue there in getting that record, and we went through a lot of length to try to get that record.
Well, that was the question, counsel, was whether there was a diligent attempt to locate the anesthesiologist.
I submit there was, Your Honor, and in fact, there was a service that was made within the first 120 days in Brooklyn.
Right, but the person, whoever they served in Brooklyn, said they didn't know where the anesthesiologist was, that they had moved to another state, right?
Not exactly, Your Honor. What happened was we had located a home address for her in Brooklyn, and the doorman accepted service on her. Some time went by, Dr. Moody did not answer. We didn't know who her carrier was. We had to go to the hospital. They disclosed who the carrier was. I reached out to the carrier, and then during a phone conversation with the carrier, they said, we spoke to Dr. Moody. She denies being served. She says she doesn't live in Brooklyn. Never was it disclosed when, there's never an affidavit from Dr. Moody herself in the motions, So we don't know when does Dr. Moody claim to have left Brooklyn, but we do know that there was a service, and this is under the good cause standard of the Leader case and CPLR 306B. There was a service. In good faith, we believed it to be in Brooklyn. Still, as we stand here today, we don't know when she claims to have left Brooklyn, but we served her in Brooklyn. We thought that that was good service. During a conversation later with her carrier, they said she doesn't live there anymore.
Counsel, let me ask a question. Isn't it correct that the statute of limitations actually expired during the period after you had contacted the insurance company and gotten the information, and you didn't act expeditiously upon receiving that information and actually let the statute of limitations expire?
Not exactly, Your Honor. First of all, at that time, we didn't know there was a statute of limitations issue. We believe we served her in Brooklyn and that she was properly served. When the insurance company disclosed that, or claimed that she wasn't living in Brooklyn anymore, that was in March, and we promptly in March made the motion for the extension. So within a few days of having the conversation with the carrier, we made the motion for the extension, and that was actually granted.
Even though that wasn't my question was, didn't you get the information about the insurance on January 2nd and then waited until March 1st?
No, Your Honor. It was actually February 19th, 2019 that we got. That was confirmed. And again, that was from the hospital. In January, they said it might be one of two carriers. They weren't sure. They were going to come back. It was February 19th. That was the exact date. They confirmed who the carrier was and the policy number. And then right away, we contacted the carrier, and it was early March that we had the discussions with the carrier where they claimed that she, was not in Brooklyn. And then, the motion was made within a few days. So, once, and again, in the beginning, we had no idea. Okay, I'll come back. Thank you, Your Honor.
Please the court, Charles Cutner for Dr. Moody. We have a question of law and a question of fact in this case. The question of law is whether that service, after the expiration of 120 days, without a motion for an extension of an additional 120 days, was ever effective. We say it was not. It's a nullity. So that first service in Brooklyn, no matter what you think of it, is a nullity because what counsel had to do was prepare the supplemental summons and amended complaint and then move for additional time to serve it. That never happened. There's no dispute in this case that that never happened.
But they're arguing that they thought that service in Brooklyn was proper.
The problem is it's a nullity because you didn't have permission to serve it. You needed another 120 days. The 120 days had expired 3 months earlier. So what you had to do if you wanted to make that service, before you made that service, is get leave of court for an extension of time. That never happened. The first time an extension was given was when they went before Judge Rockhauer in the court below and asked for it. Our position on a motion to dismiss was that extension never should have been given because there was never any diligence in obtaining this record. Not a single step was taken. As late as 2016, when plaintiff's own expert said, you don't have the anesthesia record here, was an order to show cause filed to direct the court, for the court to direct the hospital to come and bring the hospital record here with the anesthesia record in it? No, nothing was done. No steps were taken. Finally, after a motion to dismiss is resolved and 120 days is now 60 days expired, a supplemental summons is filed, service is a nullity in Brooklyn, nobody answers. By the way, when this case came in, first thing I did is look up my client's name on Google and saw that she was practicing in Minnesota. Not that that's dispositive, but it wasn't hard to figure out. But the statute was long gone, and most respectfully, an extension of time should never have been granted in the first place because there was not in the interest of justice. Good cause shown was never established. That's why I said there's a question of fact.
So if I understand you correctly, you're saying the first complaint, they filed a complaint in February 2018, naming the other defendants and naming a John Doe. Then they learn that Dr. Mude should be a party to this action. But instead of seeking court permission to serve her and to amend the complaint, they go ahead and they do it on their own, and they attempt service in Brooklyn.
100% correct.
And then, once that service is actually not effected, instead of seeking an additional extension, they wait until after the statute expires before doing anything.
Yes, sir. Thank you, Your Honor.
Thank you, Your Honor. I would like to just correct that last point, Your Honor. The first service in Brooklyn was within 120 days because you can always amend your complaint without leave of the court before the time to answer. When the complaint was originally filed in February of 2018, we went into a pre-answer motion to dismiss by the hospital. So that actually pushed back the hospital's time to answer. So when
did the hospital answer? When did the hospital answer?
The hospital initially, the hospital answered after this because the hospital made a motion to dismiss based on statute of limitations. Then they finally conceded that the insanity toll did apply, and so the hospital and the gastro answered afterwards, and the complaint was amended before their answer, or within 20 days of their I don't have the exact date, but it was within the 20 days of the hospital's answer. And they also consented, Your Honor, which is another factor. The other defendants were all on board with the amended complaint. So there really is no issue there. We didn't need to go to court to do that first service in Brooklyn. That first service, time-wise, was within 120 days. There really shouldn't be issue with the timing of that. The other service, again, we did not know that Dr. Moody's carrier, because we haven't heard from Dr. Moody herself, but we did not know that her carrier was going to claim that she wasn't living in Brooklyn and that was not a good service. As soon as that issue arose, within the week, we made the motion for the extension, and that was initially granted by the lower court. So at that point, we thought, we did diligence. An issue arose before we went even further. We served her in Brooklyn. Somebody said this might be not a good service. We don't know yet. We'll serve her again. So now we have her served in Brooklyn. We served her again now in Minnesota. She served twice.
Counsel, excuse me, a couple of times you asserted that service in Brooklyn was good. Am I correct?
Well, Your Honor, yes.
You said it here, okay.
Yes.
So if service was good, did you advance that notion below and say service was good and you should move for a default judgment against Dr. Moody?
Can I just answer that real quickly? Because they rose the issue, I figured let's serve her again, because I don't know, if she's going to come back and say, the carrier says it wasn't good. I said, let's serve her again. We still have a year to move for a default. So we're still within that year. Let's serve her again. If she comes and still says there's an issue with service, now we've served her twice. So if we have to move for a default, I think that motion would have been a lot stronger because now she's been served in 2 locations. So it cuts off that path, that avenue for her. So that was the thinking, Your Honor. We still had time. Thank you. Thank you very much, Your Honor.
People v. Stefan or Stephen Robinson.
Good afternoon, Your Honors. My name is Richard Joselson. I'm here today substituting for my colleague, William Carney, on behalf of Stephen Robinson. Your Honors, even where uncharged crimes evidence share some distinctive features with charged offenses, it remains inadmissible if it's more prejudicial than probative. Here, 2 sexual assault victims of crimes that occurred 26 years and 10 years before the charged offenses were permitted to offer extensive and dramatic testimony at appellant's trial. We think that was more prejudicial than probative for several reasons. First, the charged offenses themselves already involved 2 separate incidents involving 2 entirely separate victims. So jurors already had a hold in their head, keeping things completely separate with respect to 2 distinct victims. Adding 2 additional uncharged crime victims to that situation is far more prejudicial than it would have been if the charged offense had simply involved a single incident. Second,
Wasn't identity an issue, though? Clearly an issue, and didn't this go to the issue of identity? And wasn't there a remarkable similarity between all 4 incidents?
I think there were certainly some similarities. There were some differences. For purposes of today, I'll concede that sort of first threshold of the Molyneux analysis, but there's a second step to Molyneux analysis, and that's the probative versus prejudice weighing. And so what I'm trying to advance here is how prejudicial these two.
But wasn't it also extraordinarily probative as to whether this was the same person?
I think it was not sufficiently probative to outweigh the prejudice here. Although identity was not conclusively established here, I certainly agree with that. There was considerable evidence of identity with respect to the charge offenses, wholly apart from the uncharged crimes evidence. And here, my sort of second reason on the prejudice is the remoteness of these crimes. These crimes occurred in 1983 and in 1999. It's really, to me, too much to ask of a lay jury to conclude anything other than this is a person who has been victimizing women, young women in the Bronx over the course of 3 separate decades.
Was there a Molyneux charge given to the jury by the judge?
There was a limiting instruction, Your Honor, absolutely. But Ventimiglia itself recognizes that in many kinds of cases like this, a limiting instruction is going to be of limited utility. And I think this case just illustrates that.
But in this particular case, I know you, in your papers, and to some extent you just argued it, it was very unique. These facts for all 4 instances were extremely unique in terms of what the defendant would do, what the defendant would say to the victims. I mean, so it did establish a pattern and, you know, what we used to call an MO in terms of how he engaged in these activities.
Look, I'm not going to stand here and say there were no similarities. Obviously, there were. There were differences. The charged offenses occurred both late at night. The uncharged offenses, one in the morning, one in the middle of the afternoon. The 2 charged offenses, the complainants had never seen the perpetrator before the moment of the offense. As to one of the uncharged crimes, she had seen appellant every day for 2 weeks.
We have an apology. We have an apology in all 4 instances.
Actually,
right?
I think not all of them, but
Okay.
some of them, yes.
Some of them, we have an apology. I've never done this before. I'll never do it again, right? And I think in all 4, was there not also an offer of cab fare or to pay for a lift or something like that?
I think again, not in all 4, not exactly, but I take your point. There are.
So would that not, with the instruction, mean that the probative value is going to outweigh any prejudice?
I think not, and particularly because of what happened during the trial in this case, and I need to get to that today. First, when examining these two victims, the ADA completely ignored the court's limitation on what the ruling was. The court was so clear. It said that the underlying details of the sexual acts against these uncharged victims, they're not distinctive, and they're not anything you have to prove. So you can't go into those.
Was there an objection to that?
There wasn't, Your Honor. There wasn't. But again, in weighing probativeness versus prejudice, I think you have to consider it because it was so extensive. The ADA questioned these victims as if she were proving, she had to prove these cases. She elicited the sexual acts. She then went back to make sure that they were crystal clear. There's no way that a lay jury could separate out, could do what the limiting instruction told them to do. I do have one more thing I want to talk about.
You can certainly do that on rebuttal.
I will do it on rebuttal, Your Honor.
Thank you so much.
Thank you.
Good afternoon, Your Honor. ADA Nicole Nichols for the Office of Darcel D. Clark.
So the assistant did kind of go a little bit further than what he or she had been told they could do by the judge in terms of the Molyneux.
No, Your Honor, she did not. The court stated that the assistant could elicit all the facts that are between the uncharged crimes and the charged crimes that were similar to bring out that MO. To the extent that the judge said we didn't need to prove the rape on the uncharged crimes, to bring out those similarities, she necessarily had to go into the rape. She did not delve into the minute detail of those uncharged crime rapes, but in order to bring out the fact that during the rapes, the defendant asked personal questions of the victims, That was part of that story. And to get that, she needed to ask those questions. And she basically asked the narrative, what happened next?
So in all four cases, did the defendant allegedly ask the victims whether they had a boyfriend?
Yes,
whether they
Your
were
Honor.
seeing someone?
Yeah, he asked questions, did you have a boyfriend? Are you sexually active? To the extent he asked about the boyfriends, he asked about the boyfriend's penis sizes. So those information is one of the things that we allege made his MO unique. And we had to bring that out to show the uniqueness of his MO and to show how it was similar between the uncharged crimes and the charged crimes. And we note that not only was it not objected, the court at no point told the prosecutor, she was well aware of what her ruling was, that the prosecutor had overstepped the ruling, which is a strong indication that the prosecutor's questions fell well within the realm of the judge's ruling.
So this trial occurred in 2009, or 10, something like that, 2009.
The indictment was 2009, I believe the trial was 13.
At least one of the incidents, I thought, was in the late 80s or the 90s. So
yes.
What about that? I mean, doesn't it seem a little remote? I know for Sandoval, we normally do 10 years. So now we're beyond, if we use that as kind of a guide, now we're beyond that 10-year period. Are we a little stale or a little remote?
No, Your Honor. The reason why there's a remoteness is because the defendant was in jail during that period of time. But that should not prevent the court for Molyneux purposes in deciding whether this prior offense was similar to this offense to place defendant's identity, whereas the court recognized identity was an issue in this case. So therefore, and we note that the defendant had 6 prior cases, and the court below said all 6 were sufficiently similar that she could have permitted all to be admitted. But the court did not do that. Rather, the court crafted a careful decision where it limited only 2 cases to come in, and then gave limited instructions before each of them testified, after their testimony, that the testimony was limited only to identity, and that's what the jury is to consider it for, and again repeated that charge during its charge to the jury, its final charge to the jury. Given all of those things, and we believe that the Molyneux ruling was permissible, and the judgment in this case should be affirmed. I apologize. And just to note that the judgment should be affirmed. Thank you, Your Honor.
Thank you.
With regard to the prosecutor's violation of the court's ruling, what the court said, and I quote, "As to the details of the underlying sexual acts, they're not necessary since the people are not having to prove the elements for that purpose." If the DA was unsatisfied or thought that that was a problem, she should have moved to modify that order, not simply ignore it.
But we go back to the point that there was no objection.
There was no objection. That is absolutely right, but I do think it is part of the balance that this court has to conduct now. The last thing I need to discuss is the change in the Sandoval ruling and the way the district attorney responded to that change. The original Sandoval ruling was just the fact of 2 prior convictions, not the nature, not the underlying facts. Nothing changed, yet after the prosecution had rested, the court altered the ruling as dramatically as one could by saying, in fact, everything can come in, all the underlying facts. And look what the prosecutor did with that. Here are some of the questions or the areas that the prosecutor explored in 25 pages of cross-examination of the defendant on these issues. Weren't the victims of the uncharged crimes just like the victims of the charged crimes? Did you plan the uncharged rape, or was it spur of the moment? How did you pick the victims of the uncharged crimes? Were you looking for someone who was 17? Were the uncharged crime victims crying and saying no during the rape? Did you know that the victim of the second uncharged crime was born the year of the first uncharged crime? There is no way, though much of that with the objections were sustained. But for a jury hearing this, there is simply no way that this uncharged crimes evidence was used to do whatever it permissibly can do. There's no way that the jurors thought of appellant as anything other than a sexual predator. That's not the way we're supposed to try these cases. The people were not required to overtry this case, but that's what they did, And the implication of that, we respectfully submit should be a new trial.
Thank
you very much.
Booth versus Otis Elevator.
Good afternoon, Your Honors. Dave Roth for defendant appellant Otis Elevator. At summary judgment, Otis convincingly showed that the elevator in which plaintiff Booth suffered her accident was free from defects. It was installed in 2009 and it was state of the art at that time. And over the next 8 years, it was used probably millions of times in a busy hospital lobby without a single reported incident involving its doors. It was regularly inspected by the Department of Buildings. It passed every inspection, including an inspection done by Otis just days before the accident. It was inspected 2 times immediately after the incident and again found to be fully code compliant and working properly. And then both parties' experts conducted in-person inspections of the elevator and could find absolutely nothing wrong with any of its components. Given this evidence, Otis met its prima facie burden for summary judgment. And the burden shifted to plaintiffs to show a material dispute of fact involving a defect in this elevator. Now, the decisions in New York are very clear. The decision from Castillo from this court, Rachelin from the 4th Department, that a plaintiff can't meet that burden of showing a dispute of fact about a defect just by pointing to the occurrence of the accident.
So the court stated that while plaintiffs have not demonstrated that the components of the subject elevator were defective, the issue of which elevator button was pressed must be resolved before the strict product liability claim could be dismissed.
Yes, that's what the court said, and that's exactly the error that was the same mistake that would have been made in Rachelin. So if you look at the Rachelin case, the plaintiff in that case testified that she's driving her car, she puts her foot on the brakes don't respond, and she crashes into another car. The car goes to the dealership, it's inspected by the dealership, it's inspected by the manufacturer. They find nothing wrong with the car whatsoever. The 4th Department in that case holds that that's sufficient to show there's no defect, and the plaintiff has to come forward with some kind of evidence showing a defect. Her testimony that she pressed the brake and it didn't work is not enough to get to trial. It's the exact same testimony that was at issue here, the exact same type of testimony.
So didn't the daughter testify that she thought that she was pressing the door open button?
That is what the daughter testified to. I think if you look at the stills of the video, frankly, Your Honor, I think it's quite clear she was not. They're in the record at page 1352 and following. She appears to press the first floor button. She very...
Position, though, that it doesn't matter one way or another, whether or not she was pressing the open or the close, either way, there shouldn't be a viable claim?
Yes, Your Honor, because that's just testimony about the incident. And Rachelin and Castillo from this court involving very similar facts involving a stool says that's not enough. You can't just say the product broke and therefore the jury can infer that this product installed in 2009 has some latent manufacturing defect that's never been detected, never been found by anybody who inspected it before or afterward. That's just not enough to get to trial on summary judgment.
Well,
Castillo...
That would only be on a negligence issue, and those claims had already been dismissed here.
Yes, those claims were dismissed. They haven't been appealed, so that's not really part of this appeal here. I just want to briefly touch on the Castillo case, which I think is very similar to Rachelin. In that case, a plaintiff testified that she was standing on a stool and it spontaneously collapsed. Again, as here, the defendants inspected the stool after the accident, found absolutely nothing wrong with it, and this court held her testimony that the stool spontaneously collapsed is not enough to establish a material dispute of fact and get to trial on a manufacturing defect claim. And I just want to emphasize, why that's the case, and if it were the case that all a plaintiff had to do to get to trial on a manufacturing defects claim is just point to the testimony about what happened, and then there's no way a defendant could ever get summary judgment. There's no way that a jury verdict could ever be challenged because you're saying the jury can infer there's a latent defect in this product, no evidence of it at all that's existed for 8 years, and ignore all the evidence from experts, et cetera, that there's nothing wrong with it based solely on the plaintiff's self-serving testimony about what happened. It's not the law of New York, and the judgment below should be reversed.
Thank you.
May it please the court, my name is Thomas O'Donnell, no relation to the prior O'Donnell mentioned earlier.
Oh.
I think I heard that right, but maybe I
Yeah,
did.
you did, yeah, that was a, yeah, that
I
was
sat
a.
up when I heard that, so, Your Honor.
Thank
But
you.
in any event, I represent the plaintiffs in this action, and I simply, I want to point out just to the court, because I know it's late.
Let me ask you a question.
Yeah.
Assuming everything your client says is true, open, closed, everything happened exactly as your client testified it occurred, what about counsel's argument that a malfunction at the time of the accident is not enough by itself to make out a product's liability cause of action?
Well, if I might, Your Honor, I first want to say that what counsel's asking to do, this court to do, which the lower court wouldn't do, is find certain findings of fact.
No. My
You know,
question
okay.
to you is assuming everything your client says is true.
Right, okay.
That it happened exactly as your client testified it happened. How do you get past that all it would show is a malfunction at the time it occurred as opposed to a defect when it was first installed?
Our position, the plaintiff's position in this matter is that the harm arises from the product's failure to perform in the intended manner due to some flaw in the fabrication process.
But it's functioned in the intended manner for years.
I'm sorry?
It functioned in the intended manner for years. I mean,
Well,
it was
if you're
installed in the
pressing
70s, and it was modernized in 2009, and from 2009 until 2017, those doors functioned without a hitch.
That's a great point, Your Honor, and it's one that's troubled us. The fact of the matter is, they don't maintain incident reports. This defendant doesn't they maintain service records.
They said no complaints. They said there were no complaints regarding the elevator.
We don't know that, Your Honor, only because they don't report it to the Department of Buildings, and everything they do is self-serving. For example, in this instance here.
So you're going to speculate to the jury about that? Well, they say there's no accidents, but there could have been accidents before. That's going to be your case?
The case would be that the button, she was pushing the button, and it should have remained open. And the fact of the matter is that if, as the court has said, if we can prove that the product was not performing as intended and eliminate all causes of...
It's not, as counsel said, it's not that the product wasn't performing at the moment that the accident occurred. It's that you have to have some proof that it was not performing correctly when it was first installed. And what evidence, even if it malfunctioned 8 years later, what evidence is that it was malfunctioning at the time it was initially installed?
I'm quoting the lower court. Had she pressed the door open button, then the doors should not have closed.
I know, but we're questioning whether the lower court correctly decided it, so just citing...
I understand, but again, they don't prepare incident reports. They only prepare service reports. They didn't report this to the Department of Buildings as required by law. It's a pattern, and he calls it an inspection. I just want to point out, they call it an inspection of the elevator following the incident. The 4 things that they did: door pressure, dwell time, leveling, and also the door bumpers. That had nothing to do with the operating panel, the open button. They didn't check the open button, and they didn't check the 56 infrared beams that form the 2D matrix that part of the Lambda 3D system. And again, like I said, it's unless they can show that this thing did work properly, I submit to you that open button was never operated properly from the time that the modernization occurred in 2009.
Counsel, you mentioned that they don't report anything to the Department of Buildings or what have you. Aren't elevators inspected, and isn't there not an inspection report when the elevators are inspected?
Every year, and they made a point of saying that this elevator was a pristine elevator. That's not true. There were 2 violations noted on this, and the inspection.
But my point was that the inspection, there were no violations in terms of the door. Or of the buttons, when you push a button and it didn't work in terms of the doors opening or closing.
We don't know what's entailed in that inspection. I don't think the door operating panel.
But there was never a violation issued for that.
No, not that. As far as I know, the 2 violations had nothing to do with the. But we don't know if anybody on behalf of Otis ever checked the door open button.
Isn't that part of the inspection of the elevator?
I don't believe so. I don't believe so. They've never indicated that it was, and I'd like to pursue that at the time of trial, because I do think all of those are material issues of fact, which only really a jury should address, not the lower court and not this court, respectfully submitted. And we ask for that opportunity.
Thank you.
If there are no other questions, I'll rest on my papers. Thank you, Your Honors.
Counsel, your
just two quick-
adversary says that the inspection of the elevator was deficient, that it didn't cover the portions of the elevator that are actually in question, to wit the, I don't know what to call it.
The door panel, yes.
Yes, thank you.
Yeah, well, I think there's a little bit of an issue, which is, the problem is that the plaintiff's theory below wasn't about the door panel. The plaintiff's theory below was entirely about the beams and the 3D system. So they deposed both of the Otis elevator mechanics who did these inspections. They didn't ask them any questions at all about the elevator panel. So, frankly, I think the reason there's not...
And your adversary also says that there was no inspection with respect to the panel, the beams.
I do not believe that is correct, and it is certainly not correct that the experts did not test that. The Otis inspector who tested the elevator before the incident testified that he did in fact test the beams as part of that. It was working just fine. I'll note that the trial court found that the plaintiff's theory about the beams being defective was contrary to the video. It dismissed that. Plaintiffs have not appealed that decision, so I don't think that's really a basis for any issue here. The last point is, counsel mentioned the Department of Buildings. They make regular reports to the Department of Buildings. Our expert reviewed the Department of Buildings reports and found no indication whatsoever that there was a problem with the door panel. And I also will just note in conclusion, this is an elevator that's used probably 1 million times. It's been in a very busy hospital. The average elevator is used 500 times a day in New York City. Over 8 years, that's millions of uses. I would expect if there was a defect from 2009 involving the door open but not working, there would be some kind of indication of that being a problem. We ask that the judgment below be reversed and summary judgment be entered in Otis's favor. Thank you, Your Honors.
Next case on for argument is the people of the state of New York by the Attorney General versus Leasing Expenses Company, LLC. Justice Hillman is recused on this matter.
Good afternoon. May it please the court. I'm Thomas J. Cavalier of Cahill, Gordon, and Reindel. I'm counsel for Nesleff, Sarah Krieger, and the trusts, but I'm speaking today on this point on behalf of all respondents. It's very important that I be clear at the outset as to what it is I'm going to address and why it is important. This is about the rule of law, not the popularity of the respondents or the social utility of the global micro-ticket leasing business. Today, your first argument and the last one, two back, were criminal cases. And in both of those cases, I listened very carefully. The appellant never once said he didn't do it. He addressed various procedural defects because those are important rights. And this court vindicates those rights frequently in criminal cases, no matter how reprehensible the crime. Here, too, there is a legal principle involved. The legal principle, which is a fundamental question of due process, is whether this case stands upon the record of this case or whether the petitioner can avoid the dearth of record in this case by pointing to a record in a prior case to which all of the respondents in this case, save one, were not parties. If she's able to do that, then she can avoid the fact that she can't satisfy any of the existing legal theories in New York for visiting the results of case one on someone in case two.
Counsel, who is the she? Are you referring to the Attorney General?
Attorney General, yes, ma'am.
Ah.
Petitioner. The petitioner does not argue res judicata. The petitioner does not argue collateral estoppel. That leaves two theories that she does argue. One is alter ego, And the other is, it's available to her to argue, but she can't prove it because she doesn't have the record, that these respondents separately, not in the other case, but in this case, these different respondents themselves committed wrongdoing. Let me address both of those. I'm sorry. Aware of her inability to make either of those cases, what she argues instead is a creature unknown to New York law. There's no New York Court of Appeals case, and there's no case from this court that sanctions the theory of continuation. The word continuation, or its conjugates, appears a dozen times in the brief in this court. The argument here is essentially guilt by association. Corruption of the blood was established, was overturned by the Constitution in 1789, Article 3, Section 3. It's come back. We are guilty, we're told, because some other company was guilty in another case. And two of you sat on the panel in that case. You know that the record in that case is completely different than the record in this case. Let me first address quickly alter ego. There are the 9 fantasia factors. As we point out in the briefs, in this case, petitioner satisfies not one of them. Not one of them. So alter ego is simply not available. In terms of the liability of these respondents for their own conduct, all you have to do is contrast this case with the prior case. Here are all the things that were in that case that are not in this case. In this case, there are no forgeries. There's no non-delivery of equipment. There's no refusal to accept back defective equipment. There are no lawsuits by these clients, these people this time, against anybody. Last time, there were dozens, hundreds, thousands of default judgments, 19,000, I think. In this case, there's not a single one, not one. There is testimony by the people in this case that they don't sue anybody or they haven't sued anybody. All the things that Judge Billings pointed to, which in the aggregate, in her judgment, in the aggregate, gave rise to liability, are not present in this record. And Judge Billings said, in her opinion, if one of the respondents had put in an affidavit controverting these assertions, that would have been different. Well, here, Ariel Schechter put in an affidavit, and Sarah Krieger put in an affidavit. At a minimum, it's a question of fact. How can you grant summary judgment in the face of those affidavits which are unopposed by the petitioner? She has no fact affidavits. She has lawyer affidavits. That's all. One last point before I sit down. Due process. In prior cases involving exactly the same kind of affidavits, the Pluderman case, which I know you're all familiar with, Pluderman case went to trial court, this court, the New York Court of Appeals, trial court again, this court again, on the basis of affidavits. We lost up and down. And then Justice Hillman, who's recused, held a 16-day evidentiary hearing and he heard live testimony. He reversed himself and he said none of that was true, and this court affirmed him. Here, we have not examined one witness. We have not cross-examined a single witness. Nobody has testified against us. These affidavits, there's a long history of where they come from and why they all say what they say. But in this case, there are 3 of them, and none of them speaks to any respondent. In Judge Billings' first case, there were hundreds of affidavits, thousands of affidavits. 873, I think, was the answer. This case is not that case. If the Attorney General can get away with saying, well, your predecessors were bad people, so you're a bad person, then we have no rule of law. I'll save 1 minute for rebuttal.
Good afternoon, Your Honors, and may it please the Court. I'm David Pecan, Proskauer Rose, on behalf of Appellant's Leasing Expenses Company and Ariel Schechter. My clients join in the arguments of Mr. Cavalier on the issue of alter ego, as well as our moving and reply briefs. Mr. Cavalier correctly pointed out that there is truly a dearth of evidence to even begin to establish complete and total domination, much less for an unlawful purpose. What I want to spend my time today addressing is an issue that's unique to my clients, and that's the issue of which leases did Justice Billings rescind in her June 8, 2020 order. It's an important issue, Your Honors, because the petitioner argued and the court the trial court ultimately agreed that Leasing Expenses had serviced leases that had been rescinded.
So I know you both mentioned Justice Billings, but I thought this was an order from Justice Engoron where he granted the injunction.
He did, Your Honor, but part of the basis upon which Justice Engoron granted the injunction was the argument that petitioner had made that my clients had serviced leases that Justice Billings had rescinded in her June 8th decision. And Your Honor, that's simply not correct. In fact, Your Honor wrote the decision in the Northern Leasing Appeal, and at 193 AD 2nd at 72, Your Honor described the relief that was being sought in that case. And there, you point out that the state brought this special proceeding against respondents to, to rescind all of the EFLs, that's the equipment finance leases, obtained by fraud or misrepresentation. And that's precisely what Justice Billings ultimately concluded. She concluded that the only leases that she was rescinding were those that had been procured by fraud, those that had been entered into due to the fraudulent inducement by the Northern Leasing respondents' ISOs. And we know that because that's actually the very language Justice Billings used. Justice Billings said, quote, since the NL respondents procured their equipment finance leases through fraud under Executive Law Section 6312.
Counsel, aren't these leasing agreements substantially identical to the ones that involve Northern Leasing? No cancellation clauses, automatic renewal clauses, personal guarantee provisions, except that this time, instead of venue being New York being designated, New York City courts being designated as the venue and New York State being the forum, et cetera, don't we have Cook County, Illinois as the new?
Well, Your Honor, first off, my client only services leases, Leasing Expenses. Mr. Cavaliar's client is the one, but I think I can speak for him. I'm sure he'll speak for himself. Justice Billings found that none of the leases that the Northern Leasing respondents had originated were unconscionable. There was nothing wrong. These are standard leases. The leases that were used are used by all the companies in the industry, and that's partly why Justice Billings couldn't say that they were unconscionable. What Justice Billings concluded was the way they were originated, right? The way the ISOs went about through misrepresentations to customers and obtained it. That was what was the reason for the rescission. My client, and this is the critical point, my client had a policy not to service leases that were rescinded, that had been originated by fraud by the Northern Leasing respondents. Petitioner's argument, and what Justice Engoron concluded, was that any lease that the Northern Leasing respondents ever touched from this period of April 11, 2013 to the present were rescinded, which makes no sense because there were numerous equipment lessors, right, who Northern Leasing only serviced those leases, never owned them, much less originated them, merely serviced them, and under the interpretation of Petitioner and Justice Engoron, all of those leases, every single one of them would be rescinded. Well, that would be clearly a violation of due process. None of those equipment lessors were present. My client, if I can just finish this point, my client was very careful to make sure that the leases that they were servicing were not ones that had been procured through fraud by the Northern Leasing respondents' ISOs.
Thank you.
Good afternoon, and may it please the court. Blair Greenwald on behalf of the state. Supreme Court here properly concluded that appellants have used NLS and Leasing Expenses as successor entities in order to collect on leases rescinded by the June 2020 order affirmed by this court, and have used the same playbook to obtain materially identical leases through the same fraudulent practices despite consumer complaints of fraud. In fact, the state's evidence and appellant's own admissions in this case demonstrate that the two new entities have used the same personnel and contact information, profited the same owners through the same type of trust structure, harmed many of the same lessees by collecting on the same leases, and used the same playbook of using ISOs to market materially identical leases despite reporting of complaints. The Supreme Court therefore correctly held appellants liable both directly and as alter egos of Northern Leasing Systems and related entities.
Your adversaries are asking that we compartmentalize
No.
the entities and the actions and so on. They're saying that this is so unfair because they're very different.
There are several reasons not to allow appellants to write on a blank slate when they are repeat offenders that have been held liable. First of all, Supreme Court correctly relied on the earlier decision from this court, which is judicially noticeable and actually controls here in showing that appellants are likewise liable for their materially identical conduct. In addition, appellants' due process claims ring hollow, where they could have actually participated in the earlier proceeding, but they failed to timely disclose these entities to the Attorney General.
Well, more to the point, they are claiming that they are not engaging in the same activities as the other companies were engaging in, and they're also stating that they are different entities from those other companies that we decided, that Judge Billings decided, and also this court upheld that decision.
While they were not actually named in the prior proceeding because they did not disclose these entities to the Attorney General at that time.
More so, they're arguing that the conduct that they are engaging in is totally different, separate and apart from any of the conduct that was found to be egregious.
Both appellants' own admissions and the evidence, even just in this case, shows that to be false. So appellants actually admit that Leasing Expenses is servicing the leases that were previously serviced by the Northern respondents. In fact, their portfolio almost entirely consists of those leases. They are therefore servicing those rescinded leases in order to evade the impact of Supreme Court's injunctive order of June 2020. As for NLS, clearly an acronym for Northern Leasing Systems, it similarly uses ISOs to market these materially identical leases. They do not dispute that they are materially identical. And the merchant affirmations, even just in this case, show that NLS has ignored consumer complaints of the same type of misrepresentation and fraud. As one example, John Ryan attested that an ISO represented that he would be paying for a processing service rather than credit card equipment, promised him a low cost when it was in fact exorbitant, provided him with only one page of the contract, and forged his signature. Ryan complained of this fraud to NLS, which continued to call and demand payment on the lease until he hired an attorney to go after them. NLS, in an affidavit, states that they eventually terminated the lease, although they also say nothing about whether they refunded his money. They're therefore committing the exact same types of activities. There's also evidence of numerous complaints to other government agencies, even just in the 5 months since the June 2020 order. And for these reasons, the Supreme Court properly held that they are even directly liable for fraud under 6312 here. But in addition, Supreme Court properly held them liable as alter egos. Although appellants point to some of the factors under the Fantasia test, the purpose of the alter ego analysis is to determine whether one entity is effectively acting for another in the same type of activity. In this extraordinary case, it is very clear that these successor entities are acting in line with exactly what Northern Leasing Systems and its related entities were doing. Finally, just to address Leasing Expenses' argument about the language of the June 2020 rescission order, the decision itself, and in fact, appellants admit that in the previous proceeding, Northern Leasing Systems was held liable for fraud, both in originating and servicing leases. Because they also admit that NLS and leasing expenses are engaging in at least one of those two activities, they are likewise liable for fraud here. Finally, the remedial order here was entirely consistent with the previous June 2020 order. The injunction language was exactly the same and similarly applies to both entity and individual appellants. Appellants here have demonstrated no basis to narrow that relief, where they not only continued the exact same fraudulent scheme that was supposed to be shut down after the June 2020 order, but did so despite knowing of that previous order. For these reasons and those stated in our brief, we urge the court to affirm the decision below.
Thank you. You have 1 minute, counsel.
Yes, Your Honor, I know that, and I'll be very quick. If I may be so presumptuous as to think I understood what some of you were driving at in your questioning just now, here's what's important to realize. Cognizant of what Judge Billings had held in a case to which they were not parties, Mr. Schachter and Ms. Krieger, who spent their entire adult lives in the totally legitimate and legal micro-ticket leasing industry, formed two new companies, or operated two new companies, designed and operated to avoid the things Judge Billings called out as bad. The Attorney General cannot show that they did those bad things afterwards. Everything she says traces back to the bad old days and Judge Billings' ruling against Northern. Your Honor asked why everybody talks about Judge Billings. That's my complaint. This case was tried below or argued below on the basis of Judge Billings. There's no record in front of Judge Ngoran. There is no record of any of these things. As to the rest of the points she made, we addressed them all in our reply briefs. Thank you very much.
Thank you. You have 1 minute as well.
Thank you, Your Honor. I just want to address one point that petitioner made. Petitioner pointed out that Justice Billings' order deals with both the origination and servicing. She's absolutely correct. But with respect to the rescission remedy, it dealt with leases that were procured by fraud. Justice Billings recognized separately that the Northern leasing respondents had engaged in improper collection tactics. And for that, she had an entirely different remedy. Not rescission of leases, but for all lessees and all guarantors to receive money back, a restitution remedy. And that's exactly what Mr. Cavalier explained. These respondents acted appropriately. They understood what Justice Billings' order said was verboten, and they purposely avoided it. They have conducted an entirely proper business. And they should, for that reason, we submit that the decision below should be reversed. They have put leasing expenses out of business and Northern leasing, NLSEF, out of business. Thank you very much.
Thank you.